Biafrans. This is breaking news from the Court of Appeal Division here in the United Kingdom. They have given a verdict on the release of Nnamdi Kanu. The case has been tackled, and right now I'm going to bring you the update on the screen. So stay tuned and share to your friends and family. This Biafra Battlecry Channel TV. Thank you very much. I'll see you again in another video.
Yes, Ms. Clerk.
Lords, I appear for Mr. Kingsley Kanu, the appellant, together with Ms. Eatwell and Ms. Buchanan. And my learned friend Sir James E.D. King's Counsel appears on behalf of the respondent, together with Mr. Birdling and Ms. Klimowitz. Just before I start, I think it is appropriate to do a little bit of housekeeping just to check that you have all the bundles. You should have 2 hearing bundles. One is a core bundle, one is the supplementary bundle. And the supplementary bundle should end at page 527.
527, yes.
Great.
And is there a prize if it does end at 527?
I'm not sure who the prize would be for, but yes, I think there probably is. And then there should be an authority. The authorities bundle should have been supplemented with 2 additional authorities in the last couple of days: El Masri and Bel Haj.
Yes.
And with that, I think the housekeeping ends.
Good.
My Lord, before I begin my submissions, I should say that to begin with, at least, I'll be referring to the judgment below, and that begins at page 97 of the core bundle.
Yes.
My Lords, the issue in this appeal is what obligations and the scope of the obligations which the respondent owes to British citizens who are detained by a foreign government abroad. As my Lords will have seen from the judgment below, the stakes could hardly be higher than they are in this case. 2 years ago, on 19th of June 2021, the appellant's brother, Nnamdi Kanu, was the victim of an extraordinary rendition. Mr. Kanu is a British citizen and he was travelling on a British passport. He is also the leader of the indigenous people of Biafra. He was abducted while he was in Kenya by the Nigerian security forces, held incommunicado in a secret location and ill-treated over several days. Then, on around the 27th of 2021, without any access to due process or a court of law, he was forcibly removed across the border on a secret flight to Nigeria. Once there, he was detained and charged with criminal offences which carry the death penalty. My Lords, as the judge records, and this is paragraphs 4 to 5 of the judgment, these are not just allegations of ill treatment and extraordinary rendition. They are the findings of 2 Nigerian courts, including the Nigerian Court of Appeal, the appellant, from the 13th of October, together with Ms. Eatwell, the Court of Appeal, and the 26th of October 2022. And my Lords, I don't propose to go to those judgments, but I'm going to give you the reference with Mr. Birdling, which is what that is what paragraphs 4 and 5 of the judgment below are drawn from. Check. The 13th of October, you should have 2 judgment, 2 hearing bundles. Supplementary bundle 298 to 386. One is a core bundle, one is the supplementary. And the 26th of October judgment is a supplementary bundle 212. Supplementary bundle should end at page 5. Mr. Kanu has, in the 2 years since his extraordinary rendition, been in the custody of the Nigerian Department of State Services, which I will call DSS, where he is being held in long-term solitary confinement in conditions which threaten
And is there a
his
prize if it
precarious
does
health.
end at 527?
And that, my lords, is
I'm not sure who the prize would be for,
six
but yes,
of the judgment.
there probably is.
He is there,
and
then
remains
there,
there should be
notwithstanding
an authority.
his
The
success in
authorities
the Nigerian
bond
Court of Appeal in
should
October
have
22.
been supplemented with
in
two
October,
additional
in overturning the criminal charges against him,
El Masri
that should have led to his release.
Yes.
But the Nigerian government has appealed the dismissal of those
And
criminal charges
with
to the
that,
Supreme
in the
Court
housekeeping
and has
things.
obtained a
Good.
stay in the meantime. But it's important in my submission
Before I
that the
begin my
grounds
submissions, I
of
should say
appeal
that
do
to
not
begin
on their
with, at
face
least, I'll be referring to
dispute the
judgment
findings
below,
of extraordinary
and that
rendition.
begins at
They
page
argue
97
instead
of the court.
that the court was wrong to
Yes.
find that that extraordinary rendition deprived criminal
lords, the issue in this
jurisdiction
appeal
to hear the
what
criminal
obligations
charges. And those grounds of appeal
and the scope
are in the
of
supplementary
which
bundle
the respondent owes
at
to British
pages
citizens
185
who are
to
detained by foreign
192. Just to give a flavour, as my lords will have
of the
seen
sorts of arguments
from the
that are being
judgment
run in
below,
the Supreme Court,
the stakes could
one of
hardly
the
be
grounds
higher
of
than they
appeal,
are, which is
which
at
is
supplementary bundle 2
188
years ago, on 9 says that the essence of criminal jurisdiction
the appellant's
arising
brother,
from abduction of a
Nnamdi
person from a
Kanu,
foreign jurisdiction was the
has
victim
been
of an
an
extraordinary
extraordinary
male
rendition.
captus bene detentus.
Mr. Kanu is a
translated
British
as
citizen.
wrongly
He was
captured
travelling
on a
British
improperly
passport.
detained. He is also
So
the
that
leader
is the
of
basis on
indigenous
which the appeal
has
has
been
been
mounted. That he was abducted while he was
at
in criminal
Kenya
court
by the
in
Nigerian
Nigerian jurisdiction,
jurisdiction,
notwithstanding held
findings
findings
of
of
extraordinary
extraordinary
rendition.
rendition, secret location, and ill-treated
Now that
over
appeal
several days.
still hasn't been heard.
Then, and around
Neither
the
has
27th of
Mr.
2021,
Kanu's
application
without
without
any
any
access to due
It's
process
currently
or a
listed
court of
for
law.
the 14th of September.
He was forcibly
having been
removed
adjourned
across
from a
the border
prior
on a
hearing
secret
date of
flight
May
to
2023. Once there
and detained
in the meantime
and charged with
Mr.
similar
Kanu offences
remains
which carry
solitary
the
confinement
death penalty in detention. My
Now,
lord,
as
as
the
the
judge
judge
also
also
recognises, and this is
recognises
in his
page-
judgment,
paragraph
4
3,
5 of the judgment,
the extraordinary rendition
these
is not
first
are not just
time
allegations
that the
of
Nigerian
ill-treatment
government
and
have sought
extraordinary
to
rendition.
harm Mr. Kanu.
They are the findings
4
of
years
2
earlier,
Nigerian courts in September
including the Nigerian
2017,
Court of Appeal.
while on bail for criminal
And
from the
charges.
13th of October,
Mr. Kanu was forced to
2022
flee
Nigeria
Nigeria
in fear of his life, and the 26th of
after the
October,
Nigerian
2022
military
launched a
My
violent
lords, I
raid
don't propose
on
to
his
go to those
house,
judgments, but I'm going to
in
give
which
you the
they
references,
attempted to kill
which is what
that
that
attempt
is
on
paragraph
his
4 and
life
5 of the judgment
is also a
below
finding of the
drawn
Nigerian court. The
in
30th of
January
October
2022
2022 judgment is at
judgment
supplementary
is
bundle
in
298
supplementary
to
bundle
261
to 282.
and the 26th of October judgment is at supplementary
Together,
bundle 212
all of this means
to 251.
that the Nigerian government planned and
Mr.
executed
Kanu has, in the 2
Mr.
years
Kanu's
since his
extraordinary
abduction in
rendition
June 2021,
been in the custody of
in
the Nigerian
circumstances where they
Department
must
of
have
State
known
Services
that his
from
lawful
DSS,
extradition, where he is
and
being
could
held
never have
in
been
long-term
achieved
solitary confinement
because of the risks
and conditions
posed to
which
his life.
threaten his precarious health. And that,
Now, in
my
all
lords,
these
is at,
circumstances,
the appellant,
paragraph 6
Mr. Kanu's
of the
brother,
judgment
has since July
He is there
2021 and remains there,
sought
notwithstanding
urgent
assistance from
his
the success in
respondent
the Nigerian
to obtain
Court of Appeal
Mr.
in October
Kanu's release,
22, to
in
protect
October
him from
in
harm
overturning
while in custody,
the
criminal charges
and
against
seek accountability
that should
for
have
his
led to
rendition
his release
and
ill treatment. But the Nigerian
My
government
lords, there's
has
no
appealed
dispute
the
that
dismissal
the
of
appellant
those criminal
has a
charges
legitimate
to the Supreme
expectation
Court
and
that
has
the
obtained
respondent
will
will stay
consider
in the meantime.
those requests.
But it's
That
important in my
expectation was
submission that the
identified in the
grounds
Court of Appeal's
of
judgment
appeal
in
do
Biafra,
not on their face
and I will
dispute
come
the
later
findings
to examine that
of
judgment in
extraordinary
detail.
rendition.
Nor
They
is there a
argue
dispute
instead
that the respondent
that the court
has
was wrong to
considered the
find
request
that
and taken a
extraordinary
range
rendition
of steps
deprived
in consequence.
criminal court of
Those
jurisdiction
steps are set out
to hear the criminal
in the
charges.
judgment below,
And those grounds of
paragraphs
appeal
9
are in the supplementary
11
bundle
and 22
pages
to 24.
185 to 188.
Thus,
the
192.
respondent has intervened
on Mr. Kanu's
just to give a
behalf,
flavour, raising
of
the
the sorts of
allegations
arguments
about
that
his
are being
unlawful
run in the
transfer
Supreme Court,
and
one of the
his
grounds of
concerns
appeal,
about
which is at
his
supplementary
ill-treatment
bundle
with the
188,
respondent's Nigerian
counterparts
says that the essence
on a
of
series
criminal
of occasions
jurisdiction
he
He has
arising
sought responses
from
to those
abduction of a person
allegations
from a foreign jurisdiction,
and he has also sought
has been,
reassurance,
and I'm quoting this,
about
Malay
Mr. Kanu's conditions of detention,
translated as wrongly captured or
but the respondent
detained.
has refused to go further.
So that is the basis
Even
on
though
which
he
the
accepts
appeal
it is
has been
open
mounted
to him to do
that
so.
the
He has
criminal
not
court
acknowledged
retains
publicly
jurisdiction,
that
notwithstanding
Mr. Kanu is a victim of extraordinary rendition. He has not made
Now, that appeal
representations to this effect
still
to the
hasn't been
Nigerian
heard.
government,
Neither
privately,
has
and
Mr.
he has not
Kanu's
called
application
for
for
Mr.
bail.
Kanu's
Release.
It's currently listed for the 14th
He has also
of
not
September,
taken steps
having
to
been
impose
adjourned
sanctions
from a prior
on
hearing
anyone
date
responsible.
2023. And my lords, he's
And
explained
in
the
the
approach that
meantime,
he's taken
Mr. Kanu
in
remains
3
in
disclosed
solitary
ministerial
confinement
submissions
in detention.
from the 6th of
Now,
July
as the judge also
2021,
recognises in his judgment,
the
at
6th of
paragraph
September
3,
2021,
the extraordinary
and
rendition
most recently is not the first time
on the 10th of
that the
August
Nigerian government
2022
have sought to harm
those
Mr. Kanu. Ministerial submissions, which
4
I will
years earlier
come back to
in September
are in the supplementary bundle
2017
at pages
while on
130
bail
to
for criminal
144.
charges.
Mr. Kanu
He's
was
also
also explained
Nigeria
his
in
approach
fear of
in the
Islam.
evidence of Ms. Sarah
After the
Nigerian
Nigerian
military
which is
launched
in the
a
supplementary
violent
bundle
raid
at page
on his
51,
house,
and again I will come
in
back
which
to
they
it.
attempted to kill him.
Now, that attempt on
So
his
what
life
is the appellant's
is also a
case
finding
in
of
this
the Nigerian
appeal
court
and the
from
claim
January
below?
2022.
Although the appellant
That's
wishes
judgment
that
is
the
a
respondent
supplementary
would
bundle
take these
261
as
to
the
28
judge
too.
recognises, and you can see this from the judgment at
Together,
paragraphs
all of
17,
this means
and also
that the
paragraph
Nigerian
26
government planned
and executed Mr. Kanu's abduction in June 2021 in circumstances where they must have known
his
that his
claim
lawful extradition
and is
could
does not
never
seek
have
by
been
this claim
achieved
to require the
because of the
respondent
risk
to
posed
take
to
those
his
steps.
life. It is the
And in all
appellant's
these
case
circumstances,
instead
the appellant,
Mr. Kanu's
that in
brother,
order to take a
has
properly
since
considered
July
decision
2021
as to what
steps
steps to
urgent
take
assistance from
the
the respondent
respondent
must first
to obtain
reach
Mr.
a
Kanu's
clear
release,
internal
to
view
protect him from
as to
harm
whether
while in
Mr.
custody,
Kanu has been
and
the
to seek
victim
accountability
of extraordinary
for his
rendition
rendition and ill treatment.
The appellant says that
There was
there's no
clarity
dispute
on this
that the
prior
appellant
question
has a legitimate expectation
is an essential component
that the respondent
of a
will
lawful
consider
decision-making
his
process.
That
and
expectation was identified in the Court of Appeals
his
judgment in
Mr.
Mr.
Kanu's legitimate
and I will
expectation.
come later to examine that judgment in
But the
detail.
respondent has instead,
Nor is there a
starting on the
dispute that
30th of June
respondent has
2021,
considered the risk
the
request
day after
and
Mr.
taken a
Kanu was
range of
charged
steps
in a
in
Nigerian
consequence.
court.
And those
Maintained
steps are set
only
out
a
in the
provisional
judgment
view
below as to the
at
legality of
paragraphs
Mr.
9,
Kanu's transfer
11
and detention
and 22
My
to
lords,
24.
can I now ask you to turn up Ms.
Thus,
Broughton's
state
respondent has
in the
intervened
supplementary
on Mr.
bundle
Kanu's behalf, raising the allegations
at
about
page
his unlawful
68.
transfer and his concerns about his ill treatment with the respondent's Nigerian counterparts on a series of occasions. He has sought responses to those
The
allegations.
statement begins
and
at
he has
page
also sought
51.
reassurance about Mr. Kanu's conditions of detention.
And at page 68,
But the respondent has
is
refused to
paragraph
go further,
45,
even though he accepts it is open to him to do so.
which lists,
He has not
which is
acknowledged
part of a
publicly
list
that
of
Mr.
updates
Kanu
on
is a
new
victim of
information
extraordinary
that
rendition.
were given to ministers.
He has not made
And you'll see it
representations
be
to this effect to the
that on the
Nigerian
30th of
government
June
privately,
2021,
and he has
the
not
respondent's
called
official
for Mr. Kanu's
updated
release.
Minister Duddridge,
He has
the Foreign
also not
Secretary
taken
and Minister
steps to
Adams,
impose sanctions,
setting
on
out the
anyone
steps that were being taken
responsible.
in Mr. Kanu's case,
And
and
my lords,
containing
he's
an
explained
FCDO's
the approach that he's
official
taken
provisional
in 3 disclosed
as to the
ministerial
likelihood that Mr.
submissions
Kanu's transfer
from the 6th of July
constituted extraordinary
2021,
rendition,
the 6th of
and his
September
arrest and detention
2021,
violating
and most
international
recently
human rights laws, and as
on
to
the 10th of
involvement
August
Kenya.
2022.
And
Those
the same point
ministerial
was made
submissions, which I will come
page-
back to,
paragraph
are in the supplementary
47E
bundle at
on
pages
page
132 to
72.
144.
On the 8th of July,
He's also explained
A briefing
his approach
note
in
was
the
given
evidence of Miss Sarah Broughton,
to
which is in the supplementary
the
bundle
respondents,
at page
officials who
51.
were meeting with
Again, I
the
will come
Nigerian
back to that.
foreign minister, containing, you'll see at the end of that,
So what is the appellant's
paragraph,
case
subparagraph,
in this
an official's
and the claim
provisional
below?
view as to the
Although
legality
the
of Mr.
appellant
Kanu's transfer
wishes that the
detention
respondent
and the likelihood
would take these
of trial.
steps, as the judge recognises, and you
My
will
lords,
see this,
that
from the judge
provisional
of
paragraphs
that
17
view that
and
he has
also
taken has
paragraph
remained
26
provisional or preliminary ever since. And it remains so to date, notwithstanding the developments
It is
in the
not
evidence and the passage of time.
his claim,
And we can see that from the following,
and he does not
letters
seek by his
and
claim
to
other
require the
documents.
respondent
So the letter
to take those
the
steps.
respondent's letter of the 14th of April
It is the
2022,
appellant's case
which is
instead
under challenge. One of the
that
decisions
in order
under
to
challenge
take a
in
properly
proceedings
considered decision
is at 435
as to what steps to take,
to
the
437.
respondent must first reach a clear internal view as to whether Mr. Kanu has been the victim of an extraordinary rendition. The appellant says that clarity on this prior
This is a
question
letter that was written in response
is an essential
to a
component
request
of a lawful decision-making process and essential
on the 23rd of March 2022. You can see this
Mr.
from
Kanu's
paragraph
legitimate
20.
expectation.
From paragraph 1.
But the respondent
request
has
from the
instead,
appellant to acknowledge
starting on the 30th of
that
June
Mr. Kanu
2021,
had been subject
the
to
day after
extraordinary
Mr.
rendition,
Kanu was
and you can see
charged
at
in
paragraph
Nigerian
3,
court, maintained only a provisional
the FCDO does not
as to the
consider it would
legality
be
of
appropriate
Mr.
to
Kanu's
confirm
transfer
unequivocally
and
that
detention.
Kenya or
My
Nigeria's
lords,
conduct
can I
was in
now
breach
ask you to turn
of
up Mr.
international law.
Broughton's statement
Instead,
in the
the
supplementary
FCDO
bundle
considers the appropriate response is to continue to raise the
at
circumstances
page
of Mr. Kanu's arrest
68
with both
governments.
Similarly, in a letter of 9th of June 2022, this is a response to the pre-action protocol letter.
The statement
457
begins at
to
page
461.
51 and at page
paragraph 4.
68 is a paragraph
Previous correspondence
45B
has set out the considerable diplomatic efforts
which
being
lists,
made, including
which
at
is part of
highest
a
levels,
list
to provide
of
Mr.
updates
Kanu
on
with
new
consular
information
assistance and
that
to
were
make
given to
representation on his
ministers.
behalf.
And you'll see
In
at
deciding
B
to take these steps,
that on the 30th of
the
June
Secretary of State 2021 formed a provisional
respondent's
piece of
officials
information available to
updated
her
Minister
as to whether the allegations
the
are
Foreign
credible,
Secretary
and
and Minister
as to whether
Adams,
they either do
setting
or
out
may
the steps that were
constitute
being
a
taken
violation
in Mr. Kanu's
of
case,
international law,
and
The
containing
Secretary
an
of State shall
FCDO's
view
officials
provisional share this view and does
as
not
to the
consider it
likelihood that Mr.
appropriate
Kanu's transfer
constituted
then again,
extraordinary rendition. At
and
paragraph
his arrest
17,
and detention violating
the Secretary of State has
international
considered
human
what
rights
steps would
laws
most
and as
assist
to the
Mr.
involvement
Kanu
of Kenya.
with regard to her provisional
And the same point is
This is
made
at page
at
459 as to the
page
legality and
paragraph
gravity of Mr. Kanu's
47E,
as well as
on
the
the page
representation
72
submitted by your client alongside
on the 8th
right
of
from the
July.
FCDO. A briefing note was given
And in Miss Broughton's
to
statement,
the respondents' officials who were
turning
meeting
back
with
to
Nigerian
that
foreign
in
minister,
the supplementary bundle
containing, you'll see at the end of that, paragraph
7,
an official's provisional view as to the legality of Mr. Kanu's transfer.
I'm sorry, the supplementary
and the
bundle
likelihood
of trial.
65.
My lords, that provisional view, or that view that he has taken, has remained provisional or preliminary ever since. And it remains
This
so
statement
to
you'll
date,
see
notwithstanding
which
the
is at
developments
page
in the
76,
evidence and
dated
the
the
passage
4th of
time.
October 2022.
And we can see that from the following.
See, so
letters
at paragraph 39,
and,
when
other
considering what
documents.
further
So
steps
the
are
letter,
necessary,
the respondent's
the
letter
FCDO
will
14th
often,
of
as
April
it is done in this
2022,
case, which are preliminary
which is under
view as
challenge,
to the
one of
credibility
the
of the
decisions under
allegations
challenge
based
on the material
proceedings,
available.
is at 435.
In conducting this
437,
assessment, the weight that is accorded to various pieces of evidence varies depending on the circumstances of the individual case. My lords, rather than me read this out, could I ask you, because these paragraphs are going to be important, to read paragraphs 39 to 42,
Yes.
or 43 in fact. This is a letter that was written in response to a request on the 23rd of March 2022. You can see this from paragraph from paragraph 1, a request from the appellant to acknowledge that Mr. Kanu had been subject to extraordinary rendition. And you can see at paragraph 3, the FCDO does not consider it would be appropriate to confirm unequivocally that Kenya or Nigeria's conduct was in breach of international law. Instead, the FCDO considers the appropriate response is to continue to raise the circumstances of Mr. Kanu's arrest
with both governments. And similarly, in the letter of 9th of June 2022, this is a response to the pre-action protocol letter at 457 to 461. At paragraph 4.
Yes.
Previous correspondence, on the basis of that preliminary view, has set out the considerable diplomatic taken as to whether made, including at the highest levels, that to provide Mr. Kanu with also been taken into account and to make representation. And then at 42, in deciding to explain that forming a decisive view in the face has evolving evidence would not be appropriate on the information available to and that as to whether the alley concluded credible, not change, and as to whether they either do or may constitute a case. And at 43, Secretary of State does not foresee what new evidence will come to light. To share this view would does not consider appropriate to do so, which is at 60. And then again, C, at paragraph 17, the Secretary of State has considered what steps would most assist Mr. Kanu with regard to her provisional. You'll see that the submission that was made as to the legality and gravity of Mr. Kanu was made on the 10th of August, as well as the representation submitted by your client alongside. Considered the option of calling for Mr. Kanu's release. And in Ms. Broughton's in the middle of that paragraph, the government's policy was that turning back release should be a last resort in the circumstances. And at the end of that paragraph, the submission also considered provisional and legally privileged advice, so we can't see it, as to Mr. Kanu's allegation at 65 was Ms. Broughton's position on the 4th of October 2022. My Lords, it hasn't changed in the light of the judgments of the Nigerian. This statement you'll see at the end, which is at page 76, dated the 4th of October 2022, which is you'll see so an exchange, paragraph 39, when considering what further steps 473 and 475, the FCDO will often, as it has done in this case, reach a preliminary view as to the credibility of the allegations based on the material available. In conducting this assessment, the weight that is accorded to various pieces of evidence varies depending on the circumstances. And at 473, you'll see a letter from my Lord, the appellant, the solicitors. Could I ask, because these paragraphs are going to be important to read, paragraphs 39 to 42, asking towards the end of that letter, 43, what we're referring to as a paragraph of Mr. Justice Swift's judgment, which stated, paragraph 29, no doubt the Secretary of State's approach will now also be informed by the conclusions set out in the judgments of the Court of Appeal of Nigeria, given on 13th of October, post-dating the evidence filed in these proceedings. I've seen reference in correspondence to a note verbal sent on the 24th of October 22, presumably sent in the light of those conclusions. And the letter at the bottom of the page says, at last, please confirm that it remains the Secretary of State's position that the internal view on what has happened to Mr. Kanu even now remains provisional because of the evolving evidence and the constant inflow of new information. It's referring back to Ms. Broughton's statement, which you've seen. And the reply comes at page 475,
Yes.
paragraph 3. The Nigerian government is, our client is aware of the decision. The Nigerian government is currently appealing the judgment to the Supreme Court. As such, the nature of this case continues to evolve, and our client will assure he remains apprised of any. So, my Lords, you'll see that on the basis of that preliminary
That
view,
is the response to that question.
the decision has been taken as to whether to make a public statement, has been taken, and a number of other factors have also been taken into account. And then at 42, Ms. Broughton has explained that weeks later, concluded in the face of evolving evidence would not be appropriate. You can see this in the core bundle, and that reaching publishing, it concluded you would not change our objectives or how we approach the case. And at 43, she cannot foresee what new evidence will come to light. And then if I could ask you at 44C, which is at 60, to look at 44C, you'll see that the submission that was made, the ministerial submission that was made on the 10th of August, considered that, my Lords, just since you have been asked to release, at 4A, you'll see
that in the middle of that paragraph, further note for Bowles was sent to the Nigerian last report, including one on the 19th of December 2022, and at the end of that paragraph, the submission also contained provisional 475, and there was, for the first time, so as we understand it, a response as to Mr. Kanu's allegation, one of those note for Bowles from the government of Nigeria. So that we haven't had any information on the response about what that response contained, and there's been no disclosure. It hasn't changed note for Bowles in the light of the judgments of the Nigerian Court of Appeal. My Lord, so the skeleton argument is that all bundles 57, which is an exchange at supplementary bundle 473 and 475. Begins at 56. And at 473, you'll see a letter from the appellant's solicitors, Bindmans. You'll see how asking towards the end of that letter, referring to as a paragraph as being Mr. Justice Swift's judgment, to intervene in which stated. Paragraph 29. No doubt the Secretary's approach will now also be declined to take by the conclusion he has confirmed that he has considered those allegations post-dating and has formed a provisional view. I've seen reference to their credibility and on whether they may constitute presumably violation in the light of those conclusions. Declined to share the letter at the bottom of the page says at last, so my Lord, the position remains the Secretary of State's position that the internal view on what has happened to Mr. Kanu even now remains stance on whether, because of the evolving evidence and the constant and extraordinary new information, is referring back to Ms. Broughton's statement, which you've seen, and the reply comes all the decisions at page 475 on what steps to take have been taken. Paragraph 3 on this uncertain provisional the Nigerian government basis. Our client is aware of the decision. The Nigerian government is currently appealing the judgment of the appeal court to the Supreme Court. As such, the nature of this case continues to evolve, and our client will assure he remains a breach of his legitimate expectation. That's round 1. That is the response to that question, and it must there, based on a Basti case, a provisional, and the requirement that's set out there in a number of paragraphs. That is the 92, position recorded in the Secretary of State 99, and I'll come back to that a couple of weeks later. To at least start from a formulated view. You can see whether there has been a bundle breach
just before leaving,
rights and as the gravity of the resulting denial
the rest
of rights.
of that letter, so you can see
Round
what actions
1.
have been taken in the light of those developments.
Yes.
Thank you.
This is all in the appellant's skeleton
The
argument,
detail, just to get the sense.
which starts at page 71 of the core bundle. Round 2 is it's irrational due to the overwhelming evidence of extraordinary rendition and the fact that there is no prospect of that evidential position changing. And ground 3 is that the respondent has acted unfairly in not either informing my lords, just the appellant have been asked to look at it, 4A or of the factors which would cause it to shift. Some further note for Bowles was sent to the Nigerian. My lords, the judge rejected including one on the 19th of December 2022. He rejected the argument on the 2nd of May 2022. That the court in Abassi had said 475, and there was for the first time, as we understand it, a response there was no to such first step of those note for Bowles from the government of Nigeria. 28. We haven't had any information or bundle on about what the response contained, and there's been no disclosure as we'll have seen that in practice what is required is that the respondent is sufficiently informed, which is akin to the standard. My lords, so the skeleton argument is that all bundle 57 requiring the respondent to take reasonable steps to acquaint himself with relevant information. That's judgment, paragraph 28. He also said that the respondent's refusal of the request to reach a concluded view, quote, does no more than reflect the Secretary of State's opinion, this is judgment, paragraph 29, on how best to conduct affairs with the Nigerian authorities to give the greatest chance of providing paragraph assistance to Mr. Kanu, and that it's part of the conduct of international relations, the appellant's appeal. He also rejected the argument that it was irrational to intervene and maintain his away provisional view by again holding that the refusations to Secretary of State has declined to take place. He has confirmed respondent's opinion that he has considered those allegations and has formed a provisional view as to their credibility and on whether they may constitute a violation
and he
of
says at
international
paragraph
law, has
32
declined
of the
to share
judgment,
that view.
that the distinction which the
So, my
appellant
lords,
has
the
drawn
position remains that
between
the Secretary of
reaching
State's view privately and stating it publicly is stance
artificial.
on whether
That's in the
Mr.
judgment.
Kanu has been the victim of an extraordinary
paragraph
rendition
32.
is provisional. And that means that all
And
the
finally,
decisions
he has found
on what steps that there is no requirement
have
have been
the
taken
respondent to act
on
fairly
this uncertain, provisional, stating
preliminary
at paragraph
basis.
at judgment,
paragraph 35,
and it is that the
the
respondent
appellant's
is not
case in this
exercising a
that
power
that starting
that
point
attracts
is
an
unlawful
obligation of procedural
for three
fairness.
reasons.
And my lords, the appellant
It's
appeals
a
with
breach
permission
of his
against
legitimate
each of
expectation,
these
that's
conclusions.
round one.
In short, it's my submission that
Based
they're
on
inconsistent with both the law and the evidence, and the requirement
But
that
before
set
I
out
come
there in
to
a number
those
of grounds of
paragraphs,
appeal,
paragraphs
which I will take in
99,
turn, I want to
and
address
99, and
why
I'll come back to
reaching a clear
to
to
at
at
least
least
view
start
matters
from a formulated
in
view
this case.
as
Why
to
does
whether
it
there
matter?
has been a
breach
of rights and
and
gravity.
the
question
is
arises
included on
because
rights.
if, as the appellant
ground one.
accepts, the respondent may be entitled
This
to
is
keep
called
any
in the
concluded
appellant's
or clear
skeleton
view
argument,
he reaches private,
which starts
may be
at page
entitled to do that
71
in the
of
exercise
the core bundle.
of his discretion.
Round two is
and
it's
if,
irrational
as the appellant
due to the
accepts,
overwhelming evidence
of
subject
extraordinary
to any
rendition, and the fact that there is no
lawfulness, he may
prospect
decide
that evidence
subject to acting lawfully,
position
he may
changing.
decide not to take any different
And
steps.
ground three
Why does it matter whether
is
this
that the
private
respondent has acted
view
unfairly
is provisional or not?
in not
My lords,
either
the simple
informing
answer
to that question, the appellant of what
is
the
that
provisional
reaching
view
a
is,
clear view
or of the factors
as to whether Mr.
which
Kanu
would
was
cause
the
it to
victim of an
shift
extraordinary rendition
could make a difference.
My lords,
to
the
the
judge
steps
rejected all these arguments.
It
Um,
is a
he rejected
thus
the argument
a logical
that the court in
first
Abbasi had
step
said
in the
there
decision
was a
making
need to
process,
start from a concluded view,
Write this down, 'cause
saying there was no
sensitive, it's in-
such first step.
why does
That's
why
paragraph
does reaching
28
their
of the
concluded
judgment,
view
which is core bundle 113.
answer? Because
He said,
Because
as my lords will have
reaching
seen,
a
that in
clear
practice
view
what is
as to
required
whether
is that the
Mr.
respondent
Kanu
was
was
a
a
victim
victim
of
of
extraordinary
extraordinary
rendition,
which is akin to
could
the standard
make a difference to the
in
steps
the House
taken.
of Lords judgment in
Thameside.
It is thus
Requiring the
logical
respondent to take
first
reasonable steps
step
to acquaint himself with relevant information. That's judgment, paragraph 28.
On the other hand, the respondent
He also
position,
said that the respondent's refusal of the request to reach
which is
concluded
maintaining a provisional view,
quote, does no more
because he has already decided
opinion
not to
to
take
take
the additional
paragraph 29
steps
on
on
how
how
best
best
to
to
conduct
conduct
his affairs with the Nigerian
is
authorities
back to front
to
reasoning.
give the greatest chance of
It
providing
approaches
practical
the
assistance
decision-making
to Mr. Kanu
process
and
the wrong way
that it's
round.
part of the conduct of international
It
relations.
says, what would I do? And therefore,
He also rejected the argument
is it
that it was
necessary
irrational
for
for
the
the
respondent
respondent
to
to
maintain
maintain
his
his
privately
privately
as
as
opposed
opposed
to
to has he
again
been
holding
holding
that
that
the
the refusal
rendition
to state the view,
yes or no,
reflects
therefore
respondent's
what should I
opinion
do?
on what steps
That is
should be
obvious
taken
in my
best to assist
submission,
him
logical,
and is
and
part
correct
and parcel
way
of
to
the
approach
respondent's
the
assessment
decision-making
of how to
process.
conduct foreign relations.
So, what difference could it
And
make
he says at
if
paragraph
the Secretary of State
32 of the judgment
reached a concluded view
that the distinction which the appellant has drawn
it provides
between
in short,
reaching
the
a
justification
view
privately
to
to
take
take
a
series
series
of
of
escalated
is
steps
artificial
to
to in the
assist
judgment
a British citizen
at paragraph
detained
32.
abroad. My Lord, the approach that the Secretary
And
of State
finally,
takes,
he
the
has
respondent
found
takes, that there is no
when
requirement for the
a
respondent
British
to act
citizen
fairly,
is detained abroad is set out in the
stating
prisoner
paragraph
policy
at judgment
guide at paragraph 35,
which is in the
that
supplementary
the respondent
bundle.
is not exercising a power that attracts an obligation of procedural fairness. And my lords, the appellant appeals with permission against each of
paragraph
these
I want to,
conclusions.
the page
In
I want
short,
to, part I want to look at is at
It's
page
my submission
79.
that they're inconsistent with both the law and the evidence.
See,
Before I come
stance
to those grounds of
78.
appeal, which I will take in turn, I want to address why reaching a clear or concluded view matters in this case. Why does it matter to the appellant? And you can see, first of all, a distinction.
And the
that is
question
drawn
arises because if, as the appellant
between
accepts,
intervention and
the respondent
interference
may be entitled to keep any concluded or clear view he reaches private, he may be entitled to do that in the exercise of his
And
discretion. And if,
what is said is that
as
the
the
UK
appellant
government can
accepts,
intervene
subject
behalf
to
of a
any
British national under certain
lawfulness.
circumstances.
He may decide.
This is usually where we have
he may
concerns
decide
for the
not
health,
to take
welfare,
any
or
different
human
steps.
rights of British nationals.
Why does it
Will
matter
have
whether
concerns
this
that they are
private
being unlawfully
view
or
is
unjustifiably
provisional or not?
discriminated against?
And my lords, the simple answer to that question
And
is
this
that
is
reaching
what we
a
can
clear view
consider
as to
intervention,
whether Mr. Kanu was the victim of an extraordinary rendition
and a list
could
of
make a difference
possible
to the
grounds
steps
for
taken.
intervention is set out below.
It is a
Health and welfare
thus
concerns,
a logical first
torture or
step in the
mistreatment.
decision-making process.
death penalty,
Right,
and so on and so forth.
Sense that it's
We cannot consider interference.
why does reaching
Intervention
care
must be
to peer
appropriate,
review
this is at the
matter?
bottom of the page, and justified.
Answer.
Under international law, we
Because.
cannot
Because
interfere
reaching
in
a
the
clear view
internal
as
affairs
to
of
whether
another state,
Mr.
including
Kanu
their
was a
judicial
victim of
proceedings.
extraordinary
The
rendition
UK's internal
could
internal
make a
affairs are
difference
similarly
to the
protected
steps
from foreign
taken.
interference. And then there is a list
It is thus a
of
logical
matters that are likely
first
to be
step.
considered interference. Expressing an opinion, this is over the
On the
page
other
80,
hand, the
expressing an
respondent's
opinion on the
position,
guilt or innocence of the accused, seeking
which
to
is
influence the
maintaining a
judgment
provisional
on the
view
case.
because he has already
And,
decided
other examples are given.
not to take the additional
So,
steps
my lords,
that are
there is
sought
always
by the appellant. Is back to front
an
imperative
imperative
to avoid
it
interference.
approaches the
and
decision-making
to
process,
but there is a
the
need,
wrong way
nonetheless,
round.
to intervene where there are concerns.
It says, what would I do?
And therefore, but is it necessary for me to? And you can see how this works
By
in Ms. Branto's witness statement.
Has he been
At
the victim of
paragraph
extraordinary
3,
rendition?
which is
But just
yes
before
or
this
no,
in the bundle.
therefore,
page
what should I
54.
do? That is the obvious, in my submission, logical and correct way to approach the decision-making process. So what difference could it make
Sorry,
if
page
the
52.
Secretary of State reached a concluded view? It provides, in short, the justification for him to take a series of escalated steps to
This is
assist
the
a
raising
British
of
citizen
allegations with
detained
the
abroad.
with the
My Lord,
Nigerian
the
authorities.
approach that the Secretary of State takes, the
As you can
respondent
also
takes,
see in the way
when
that she
a British
describes the
citizen is
policy,
detained abroad,
is
is
set
set
out in
at
the
paragraphs
prisoner
8
policy
53,
guidance, which is in the supplementary bundle. This distinction between intervention and interference. And the paragraph I want to, what is happening,
page I want to-
part I want to look
14,
at is at page 79. When you send note for bowels, we may signal, this is at
starts
page
at
75, we
58.
may signal to local authorities who have an interest in the case by sending a note for bail. We may ask questions, this is at paragraph 14. Often,
And you can see, first of all, a distinction
that is drawn, this is from the PPG, the Prisoner Policy
between
Guidance, asking
intervention
questions
and
can act as a
interference.
prompt for concerns to be addressed, or the answers may act as the basis for further intervention.
And she goes on to describe the
And
purpose of
What
our
is
lobbying
said is that the UK
exists.
government can intervene on behalf of a British
And
national
what is clear
under
from
certain
all of these
circumstances.
steps is that forming
This is usually
a
where we have
concluded
concerns for the health, welfare, or
as
human
to
rights
whether
of
there's
British
been a
nationals,
violation of international
or have
law
concerns
is
that
not
they are being
essential
unlawfully or
to
unjustifiably
intervention
discriminated
of that type. Expression of concerns, raising allegations,
And this is what we
or seeking
can
assurances
consider
that
intervention,
a British national will receive a fair trial.
and a list of possible
These
grounds for intervention is set out below.
Types of steps can be taken
Health
on
and
the
welfare
basis of
concerns,
preliminary
views,
torture or mistreatment,
and on the basis of
the allegations that are
death
made.
penalty, and so on and so forth.
But my
We
lords,
cannot consider
those steps have
interference.
already been taken over the last 2
Intervention
years
must
in
be
Mr.
appropriate,
Kanu's
this is at the bottom
case.
of the page, and justified. Under
And you can
international
see
law, we
that,
cannot interfere in the
and Ms.
internal
Broughton has explained
affairs of another state, including
That
their judicial
the
proceedings.
allegations, this is a
The
paragraph
UK's
2,
internal
have been taken
internal
most
affairs are
seriously
similarly protected.
and repeatedly raised in
Interference.
formal communication.
And then there is a list
The latest letter
matters that are likely
my
to be
learned friend
considered
asks
interference.
you to read further into.
Expressing an opinion. This is
Again,
at page
sets out
80,
all those
expressing
types
an
of
opinion on the guilt
communications.
or innocence of the accused.
But what is important
seeking
is
to
that
influence the
justified
judgment
intervention
on a case.
is not limited to those raising those kind of
And
concerns
other
or
examples are
allegations
given.
or asking for further evidence. So it
my lords,
can include
there
more
is
robust
always,
steps.
And at this point, I would like to
an
ask you
imperative
to look
to
at
avoid
the ministerial
interference,
submission of the 10th of August
and
2022, which is
but
at
there is
page
a need
141.
nonetheless to intervene where there are concerns. And you can see how this works in Ms. Broughton's witness statement at paragraph 3, which
Supplementary
is,
bundle.
but just before this in the bundle at page 54. Now, this ministerial submission, which starts at 140, was in response to a request from those instructing me that page 52, the respondent take further steps in relation to the fact that Mr. Kanu had been the victim of extraordinary rendition, and ask for his both acknowledging raising of allegations with the respondent. And you can see, if I could ask, with the Nigerian authorities, paragraphs 8 to, and you can also see
Ministerial
in the way that she describes the policy at paragraphs 8 onwards at 53. This distinction between intervention and interference, and what is happening at paragraph 14 when you send note verbals. We may signal, this is at page 55, we may signal to local authorities we have an interest in the case by sending a note verbal. We may ask questions, this is at paragraph 14. Often, this is from the PPG, the Prisoner Policy Guidance, asking questions can act as a prompt for concerns to be addressed, or the answers may act as the basis for further intervention. And she goes on to describe the purpose of how lobbying may assist. And what is clear from all of these steps is that forming a concluded view as to whether there's been a violation of international law is not essential to intervention of that type. Expression of concerns, raising allegations, or seeking assurances that a British national will receive a fair trial. These types of steps can be taken on the basis of preliminary views and on the basis of the allegations that are made. But, my lords, those steps have already been taken over the last 2 years.
How far
Mr.
did you want
Kanu's
us to go?
just to the end of 10.
Right.
and you can see that
In the first instance, I'm going to ask you
Ms.
to take
Broughton
over
has
the page,
explained.
but
that
so you'll
she
see
said
at
the
paragraph
allegations, this is
9
paragraph 2,
that ministers retain the discretion to depart from
repeatedly
policy and
raised
call for
in
release in
formal
exceptional
communications.
circumstances, provided there's a
latest
rational
letter,
basis for doing so.
my learned friend
The principal exception
asked you to read further into,
where ministers
again,
previously
sets out all
called for
those
release,
types of
so it has been
communications.
done, is where
But
the
what is
FCDO
important
has
is that
credible
justified
evidence to suggest the
intervention
detainee is
is not
arbitrarily
limited to
detained.
those
Although to
raising
date
those
that
kind
has
of
only been done
concerns or
in very
allegations
limited
or asking for
circumstances.
further information. It can include more robust steps.
You can see there
But
and
at
it
this
is
point, I would
possible
like to ask you to look
call
at
for
the
release,
ministerial submission of the 10th of
where
August 2022, which is
there is
at
credible
page
evidence to
141.
suggest the detainee is arbitrarily detained. And realistically, given how exceptional that is, it's not going to happen unless there is a clear and Supplementary
concluded
value, I
view
should say.
has been taken that the individual, this ministerial submission, which
has
starts
been
at
the victim
140,
of
was
an
in response to a
rendition.
a
Adoption
request
remains
from
available.
those instructing me.
And you can see over the page
that why it is not recommended the respondent take what is recommended
further steps in relation
is continuing
to
lobbying
the
the fact that Mr. Kanu had been the victim of extraordinary rendition and ask for his acknowledging that fact and
calling
asking
for release is
his
exceptional. We
release.
see this at paragraph
You can
11.
see, if I could ask you then to read
human rights violations
paragraphs
cannot be
8
needs to
to
be done where human rights
10
violations cannot be
this
remedied by
ministerial
other means, where we
submission.
judge that call for release is a credible and effective step. We assess there are still further steps can be taken before consideration of this exceptional measure. Lobbying and escalation, you'll see, and at the end of that paragraph, monitoring ongoing legal proceedings in Kenya and Nigeria where the allegations are being considered. And you can then see at paragraph 13, the option is not recommended. We do not, to call for release, we do not assess lobbying has been exhausted, nor that all legal remedies have been exhausted. Nor is it clear that a call for release would be credible or effective. The civil proceedings in Kenya and Nigeria remain ongoing. And then it says here, there will therefore be opportunities for the courts in Kenya and Nigeria to consider the allegations and potentially provide remedy to the alleged rights violations. British High Commission Abuja and Nairobi can also further escalate lobbying on the allegations to try and obtain a response from both governments. And then there is a concern that calling for release at this stage, before it's a measure of last resort, could set an unmanageable precedent. And the submission then goes on to say that it will be effective at paragraphs 14 onwards. So, my lords, calling for release in exceptional circumstances is available, and you can see from Ms. Broughton's witness statement, I won't ask you to turn it up again, but it's
Sorry
a page.
to interrupt.
Yes.
Who or what is post?
I think that's the commission in the British High Commission.
Yes, how far did you want us to go?
Just to the end of 10.
Right.
In the first instance, I'm going to ask you to look over the page, but so you'll see at paragraph
And
9,
so, without turning it up again, Ms.
that
Broughton's
ministers
witness
retain
statement
the discretion to depart
at
from
page
policy and call
63
for
of the
release in
supplementary
exceptional
bundle,
circumstances, provided there's a
36A,
rational basis for doing so.
accordingly says
The principal
it's
exceptional
extremely rare
circumstance.
to definitively state that treatment
Where
is
ministers
illegal
have previously
in
called
international
for
law.
release,
This is
so it has
publicly.
been done, is where the
But it's
FCDO
rare,
has credible
but it
evidence
is
to
possible.
suggest the detainee is arbitrarily
And she
detained.
repeats, referring
Although
back
to date that has only
same
been done
policy
in
in
very
the
limited
ministerial submission of
circumstances.
paragraph
So,
36E. This is page 64.
you can see there
of the supplementary
that it is
bundle,
possible
that government policy is
to
that
call
no
for release
representations for release of
where
British nationals detained
there is credible
named
evidence to suggest
other
the
than in
detainee is
exceptional
arbitrarily detained.
circumstances and usually as a matter of last
And
resort.
realistically, given how exceptional that is,
So, my
it's
lords,
not going to
the fact that this is not merely a
unless
theoretical
there is a
option, however
clear,
rare,
and unless
is
a
made
clear
clear
and
from a
conclusive
series of
view
examples
has been taken
that are given in Ms.
the
Shirin
individual
Marker's second statement in the
has
supplementary
been the
bundle
victim of an
at
extraordinary
pages
rendition.
145 to
Adoption
151
remains available there.
and paragraphs
And you can
8
see over
to
the
27.
page why it is
And you'll
not
see
recommended.
that in those
What is
examples
recommended
that she gives,
is continuing lobbying.
the respondent has on several occasions made
Because
public statements
calling for
concerning
release
the
is
legality
exceptional. We see this at
of an
paragraph
individual's
11.
detention by a foreign
Government
government
human rights violations cannot be
and has also
needs to be done where human rights
called
violations
for their
cannot be remedied by
release.
other means where we judge that call for release is a credible and effective step. We assess there are still further steps can be taken before consideration of this
examples
exceptional measure.
date
Lobbying and escalation, you'll
From
see, and at the end of that paragraph, monitoring
over the
ongoing
decades
legal proceedings
from
in Kenya and
1984
Nigeria where the
onwards,
allegations are being
including in
considered.
relation
to the United States, rendition flights at paragraph 12.
Well,
And you can then see at paragraph 13,
paragraph
the option is
16
not
the
the treatment of Uyghur Muslims in
do not,
Xinjiang to for release. We do not assess that it has been exhausted, nor that all legal remedies have been exhausted.
and at paragraphs
Nor is it clear that a call for release would be credible.
22,
The civil proceedings in Kenya and
requests
Nigeria remain ongoing.
then
And
Foreign
then
Secretary
it says
Dominic
here,
Raab,
there will therefore be
February
opportunities
2021
for the courts
the
in
immediate
Kenya
and
and
permanent
Nigeria
release of
to
all
consider the
arbitrarily
detained
detained
dual
British
and
nationals
potentially
in Iran.
provide remedy to the alleged rights
and the
violation.
requests for release in Iran by then Foreign Secretary
British
Liz
High Commission
Truss on
Abuja
1st
and
October
Nairobi can also
2021.
further escalate lobbying on the
British
allegations to
national
try and
Laura
obtain a
Tabas
response from both governments. And then there is unjustly
Consent.
detained in Iran for
Paragraph
paragraph
24,
24.
that's
Before
its measure of last
Gary
resort.
Ratcliffe set an unmanageable precedent. Appalling and the continuation, the decision to proceed
submission
then
then
goes
goes
on
on to
charges
say
appalling continuation of the cruel ordeal at
she's
paragraphs
going through.
14. And there are other
Onwards.
examples given there as well, including at
so,
paragraph
my
26 by the
lords,
former Prime Minister.
calling
Boris
for
Johnson,
release in
acknowledging
exceptional
that the Indian government was
is
arbitrarily
available,
detaining
and
Jagtar
you can
Singh
see
Chahal.
from Ms.
So it
Broughton's
can be
witness
done.
statement, I won't ask you to turn it up
But
again, obviously and necessarily, when it is done,
Who or what
a
is
conclusion is going to have to be reached.
I think that's the commission
that
in
someone
the
has
British
been
High Commission,
arbitrarily detained.
as I understand it.
Thank you.
But that is not the only difference that a concluded view
and
could
so
make.
without turning it up
It
again,
could
Ms.
also
Broughton
make
makes
a difference to the decision as to whether
page
page 63 of the supplementary bundle
sanctions on an individual
36
to designate
A
a person
or sanctions.
So that is
Accordingly
dealt
says
with
it's
in
extremely
Ms.
rare
Marker's
to
second
definitively state that treatment is illegal.
at paragraphs
in
28
international law, this is publicly. But
at page
it's rare, but
151.
it is possible. And she repeats,
And she
referring
refers
back
then
then
to the
the same
global
policy and
human rights
ministerial
sanctions
submission of paragraph
regulation
36E
2020,
this is page
which is
64,
in the authorities bundle,
the supplementary
tab
bundle,
20,
is that government policy is that no representations for release of British nationals
Just
detained
briefly
are made
that up.
other than in exceptional circumstances and usually as a matter of last resort. So, my lords, the fact that this is not merely a theoretical option, however rare, is made clear from a series of examples that are given in Ms. Shirin Marker's second statement in the supplementary bundle at pages 145 to 151,
Regulation 4,
at paragraphs
page
8
646
to 27. And you'll see
purposes of the
that in
regulations contained in
those
this
examples
are
that
to
she
deter
gives,
and provide
the
accountability for
respondent
activities falling within
has,
paragraph
on several
2.
occasions,
An activity falls within this paragraph
made
is an activity which
public
carried out
statements
by or
concerning
on
the
behalf of the
legality
state within that
of
territory.
an individual's detention
Within the
by a
territory of
foreign
that
government,
government to a serious violation by that
and
state
has
of the
also
individual's right to life,
called for
right
their
not to be
release.
subjected to torture or cruel, inhuman or degrading treatment or punishment, or right to be free from slavery, not to be held in servitude, or required
Those
to perform
examples
compulsory labour.
date
And just
from a series
to be clear, extraordinary
decades
rendition includes
from
within
1984
its
onwards,
definition, including in
arbitrary,
relation to
detention and
States,
transfer,
rendition flights at paragraph
in the
12,
absence of lawful
process,
paragraph
paragraph 16, the
purposes
treatment
of,
of
Uyghur
Muslims in Xinjiang, interrogation under torture. So that is part of the
and
definition.
paragraphs. I can give you that's what the authorities
22,
and Bell
the
Hodge make
requests by
and then
Foreign Secretary Dominic Raab,
Regulation 6,
February
the
2021,
criteria for designating
the immediate
a
and permanent release of all
The Secretary of State may not designate a person under
Regulation
Regulation
5 unless the Secretary of State has reasonable
the
grounds
request
to
to
suspect
release
that
in
person
Iran
is an
by
involved
then Foreign Secretary
person.
Liz
An
Truss,
involved
person
person
without
without
going through the full
2021
definition is involved in
British
one of
national
these
Murad
Tabas.
Now,
Reasonable
justly
grounds to
detained in
suspect
Iran
is a
paragraph
relatively
24,
low
Lieutenant
test.
Zagari
But
Ratcliffe,
that doesn't mean that the Secretary of State is realistically
calling
going to
continuation decision to
impose
proceed with these baseless
sanctions or designated person
calling
where she has
continuation of the
only,
cruel ordeal
she is going
a provisional, and there are other
view
examples
that the
given there
activity
as well,
has taken
including
place.
paragraph 26.
And if
by
that
the
wasn't
Prime Minister,
obvious,
Boris
it is
Johnson,
made obvious by
acknowledging that the
the
Indian
guidance
government
at
arbitrarily detaining
tab
Jagtar
21.
Singh Johal.
So it can be done.
It's the designation guidance, tab
But
21 of
obviously,
the
unnecessarily,
authorities bundle.
when it is done, a conclusion is going to have
And you'll
to be
see
reached
that the factors that the government will have
that someone
regard
has
to.
been arbitrarily detained.
Following factors are likely to be relevant, but this list is not exhaustive.
But that is not the only
This is at page
difference
674.
that a concluded view could make. It could also make a difference to the decision as to whether to see paragraph 3, sanctions
The seriousness
to designate a person or sanctions.
conduct.
That is dealt with in Ms.
Majesty's
Shirin's
government is
second
likely to
statement.
consider the scale, impact,
And paragraph 28
both of the human
onwards.
rights violation or abuse and a person's involvement in that violation or abuse, including whether
And
the
she
conduct
refers
has a
then to
systematic
the
nature as
global
part
human rights and sanctions
behaviour.
regulations 2020.
So again,
which is
realistically,
in the
it is
authorities
inconceivable
bundle
that
tab
such a
20
state
would at page 645
designate somebody for
sanctions in
just
circumstances where
briefly
she hasn't
turn
even
that up.
formed a concluded view herself as to whether the underlying activity that they're said to be that there is said to be a reasonable suspicion that they're involved in constitutes a breach of international law, which is an extraordinary rendition. So that's the position in relation to sanctions. And you'll see Regulation 4, respondent's own approach to that in the ministerial submission of 6th of September
Purposes of the
2021,
regulations contained in this instrument,
which is in the supplementary bundle
and provide
at
accountability for
139.
activities falling within paragraph 2. An activity falls within this
This is our
paragraph
approach to
an
it in
activity
this
which
case.
carried out by or on behalf of the state within that territory. Within the territory of that state would amount to a serious
And I
violation
should
by
say,
that state of an individual's right to life.
That
Right,
make
not to be
clear that the
subjected to
first
torture
two
or cruel,
ministerial
inhuman or
submissions
degrading
included
treatment or punishment.
this was the second
Right to be free from
July
slavery, not to be
2021
held in servitude.
and September
required to
2021
compulsory labour.
were made
Just,
before the respondent had gained access
to
to
be
Mr. Kanu
clear,
in detention.
extraordinary rendition includes within its definition.
They were made
arbitrary
before any detention
clear
and
information
transfer
had
and
the absence of
emerged.
lawful process.
So this is
for the
139
purposes of
the start of the
treatment or,
submission
is at
Interrogation
134.
under torture. So that is part of
And
the
at the back,
definition.
there is an annex of options,
That's what the
recommendations as to what
and Bell Hard
course to take, and then there is
so,
an annex of alternative
and
options
then
which are not recommended.
Regulation 6.
And you can see
the criteria
at
for designating
139,
a person.
the Secretary of State may not designate a person under Regulation 5 unless the Secretary of State has reasonable grounds to suspect that person is an involved person.
And an involved person, without going through the full definition, is involved in one of these activities. Now, reasonable grounds to suspect is a relatively low test, but that doesn't mean that the Secretary of State is realistically going to impose sanctions or designate a person where he has only reached a provisional view that the activity has taken place. And if that wasn't obvious, it is made obvious by the guidance.
So the respondent was looking for
tab
evidence
21
to substantiate
the allegations.
the designation guidance.
With tab
for
21 of the
considering
authorities bundle imposing
and you'll see
for
the
deciding
factors that the government will have regard to.
case meets the evidential thresholds. So that's
Following
sanctions.
factors likely to be
Diplomatic
relevant, but this
protection
list
is
is
another
also-
option that is available. This is at page 674, and that's described in the prisoner policy guidance. And you'll see in
page
paragraph
104,
the seriousness
I don't know much about this.
of the conduct.
Can you do that?
Her Majesty's government is likely to consider the scale, impact, and nature, both of the human rights violation or abuse, and a person's involvement in that. There will be, there may be a whether the conduct has a systematic nature or is member state behaviour. Sorry, the other states. So again, realistically, it is inconceivable that the Secretary of State would designate somebody for sanctions in circumstances where she hasn't even formed a concluded view herself as to whether that was done in the underlying activity that they're said to be, there is said to be a reasonable suspicion that they're involved in. And you can see, so diplomatic protection is dealt with in the prisoner policy guidance rendition at page 104. So that's the position in relation to sanctions, and you can see the respondent's own approach to that in the ministerial submission of September 2021, which is in the supplementary bundle at 139. Sorry, 104, you'll see that diplomatic protection at the bottom of that page. Diplomatic protection approach to it in this case is the process under international law by which one state pursues a claim against another state on the basis that it has committed an international wrongful act against its nationals. Make clear that the first two ministerial submissions include, and this is the second, necessary July 2021 and September 2021, were made before the respondent had gained access to, you'll see again at 105 through. So they were extremely rare. This is just their information under the heading diplomatic protection. Right at the state. This is 139. In practice, diplomatic started very rare and considered on a case-by-case basis. Exercise is at 134. That's the back. There is an annex of options, conditions to recommendations as to what the conditions that must be present to take present, and then there is an annex of alternative options with the permission of an internationally wrongful act. And you can see at 139 the sanctions guidance option on diplomatic protection. You can see. I could just ask you to read that. They may take up a claim for a dual national in a third country. HMG will not normally take up the claim of a dual national in their country or other nationality. However, exceptionally, HMG may take up the claim of a dual national against their country or other nationality where it has treated them as British nationals in the circumstances that gave rise to the injury. So,
is that this case?
well, my lords, I can see that is something that would have to be considered as to whether he had been. So the respondent was looking for evidence in this particular case, but that would the point as far as considering this submission is concerned is that these are all criteria that need to be considered, and one of the criteria is whether there's been an internationally wrongful act. So that's sanctions. Diplomatic protection is another option that is available. And that you can see that in the again in that policy guidance submission
at
page
sorry, in the
104.
ministerial submission of September
I don't
2021,
know much about
139,
Can you do that where the individual
that diplomatic
feels-
protection was one of the options considered.
It is, yes, you can.
We could
I mean, there will
extending
be,
diplomatic
there
protection
may be a
to Kanu,
dispute with the,
although it is unlikely that he
member
would meet
states.
the criteria for
Also,
consideration
sorry, the
as
other
domestic
the other
avenues
states
have not
as to
yet
whether
been
they would
exhausted. So
accept
that's the reason that's given. It's not
that
the
your
reason
protection is being
that he's not being treated as a British citizen
on
in the Act.
approach to
But I should say, I said at the start that
that was done in
Kanu was
fact
travelling
to Nazanin.
on a British passport
Who was a dual national.
when he was transferred.
And you can see, so diplomatic protection is dealt with in the
diplomatic
policy
protection
guidance
is
one of the options.
at page
But only
104.
where local remedies
Yes,
have not been exhausted.
well, that's right, but that also means when it looks as if those remedies are not.
And you'll see at 105.
So these are a part of, it's part and parcel of the,
sorry, at 104 you'll
assessment
see
that
that
has to be
diplomatic
made,
protection
whether
at the
there's
bottom
been
of
an
that
intentional
page.
wrongful act.
Diplomatic protection
but
is the process under
diplomatic
international law by
protection
which
is one of
one
the options.
state pursues a claim against another state on the basis that it
I
has committed
absolutely
an
accept that
international
it is
wrongful act
the
against
last
its
option
national. So
in a series of
commission of an
options.
international,
But it is an option,
and it is a further reason
necessary
when someone has been
prerequisite
detained for solitary
considering whether
confinement
to
for 2
impose it.
years to reach a conclusion.
on
And
whether
then
they are
you'll see
were the
again
victim
at
of extraordinary
105.
rendition or not.
It's
my
extremely
lord,
rare. This is
calling
just
for release,
under the
making
heading
statements
diplomatic protection, a right of the
about
state, the third paragraph.
whether
in practice
someone has
diplomatic
been
protection is very
victim
rare and
of a-
considered on a
of an
case-by-case
international
basis, exercise
of
of discretion
a
of
breach of
Foreign
international
Secretary.
law, in this case extraordinary
This
rendition,
means there's no duty to
sanctions,
exercise it, even if
finally,
conditions to exercise it are present.
diplomatic protection
Conditions
rule,
that must be present
options
to
that
consider
are
diplomatic
available as
protection include the
escalation
commission of an international
when
wrongful act,
the
exhaustion
expressions of
remedies
concern, the
include
note verbal, the
nationality.
lobbying has not worked.
And then there is guidance.
And in my
on
respectful submission,
diplomatic protection,
reaching
you
a
see,
concluded
they
view,
may take up a claim for a
clear and
diplomatic
concluded view, as opposed to a non-provisional view, is a critical
HMD will not
component
normally take up a
of
claim
properly
for national
considering
country of other
those
nationality.
options.
However, exceptionally,
And
HMD may take up a claim for
a
dual
difference.
national against their country or other
So
nationality.
can I
of other
turn now to the
nationalities
grounds
where
of
treated
appeal?
as British nationals.
And the
in
first
circumstances
ground
that
Ms.
gave
Kilroy,
rise
just
to
before you do, can I just ask you, was just talking around this
So,
question of
Is that
concluded
disclosed?
view,
well,
taking it in stages.
My lords,
I assume you accept that
I can see
initially
that that
at
is
least,
something that would have to
the
be
Secretary of State was
considered
entitled to
whether
form a
he's been
provisional.
treated as a British national. Yes, in this particular
So-
case, but the point.
When was it,
The point as far
you
as
say,
this
that he was
submission is
obliged
concerned is that
to come to a
these are
concluded
all
view?
criteria that need to be considered,
When it's-
and
when
one of
the
the
evidence
criteria is
warrants-
whether there's
warrants
been an
it.
international
No, when
wrongful
on
act.
your case,
Oh, I see.
was he obliged to come to a
Against a British
conclusion? And then obviously the follow-up question is why? Because this is actually all
and
temporal.
you can see that
So
again,
I
in
just
that
want to try and understand
submission,
what the case
sorry, in the
is,
ministerial submission of
as
September
to
2021,
when and why
139.
the position would have shifted.
Well, I mean, diplomatic
first and most
protection
obvious
is
one
one
of
of
the
the
options
options
is
to
a
consider.
precise date.
I could,
Of course, accept
consider
on the
extending
appellant's
diplomatic
behalf that in the
protection to
initial
Kanu,
days,
although it is
when
unlikely
an
that
individual has
criteria for
been
consideration as
detained,
domestic avenues have not yet been exhausted.
a
So
process
that's the
of
reason that's given. It's not the
investigation
reason
has to be undertaken
that he's not being treated as
to
a
establish the
citizen
circumstances in which they've
in
been
the
detained.
Act. But
And the
it,
lawfulness
I
of
should
their
say, I
treatment.
said at the start that Mr. Kanu was travelling
And in order, I
on a
also
British
accept,
passport. Indeed,
I assert that in
when he
order
was
in that
transferred
period of
to
investigation, the respondent
so
is quite right. not
diplomatic
to
protection is one of the options.
simply take
But
no action.
only where local remedies
Yes,
have not
to
been exhausted.
express concerns
Well,
based
that's
on
right, but
preliminary, but
that
that
also
also
means when it looks
that
as
she
if
is
those
able,
remedies
he
are
is
not
able to reach,
effective.
and we are on
So
the treatment.
these
of
are
that individual.
These are a part of,
But as
these
the
are
evidential
it's part and
picture
parcel
develops,
of the assessment that has to be made,
whether there's been an
um,
internationally wrongful act, except there are other criteria,
then the Secretary of
but,
State
diplomatic
is, in my
protection
respectful
responsible
submission,
submission
obliged
It's simple. To
as soon as it
I
is
absolutely
possible to
accept
do
that
so,
it is the last
reach
option,
in a
clearer,
series of options.
non-provisional, but it is an option.
And in this
it is a
case,
further reason.
when someone has
What
been
happened
detained
was that the
solitary
Secretary of State
confinement
was for 2 years
for to reach a conclusion, requesting
whether they
explanations
were the
by way of
victim of
extraordinary
trial
rendition or not. See that from Ms Sprouton's statement.
So,
As
my
to
lord,
what had happened,
calling for release,
making
making
a
a
statement, the
statement
circumstances of his
about
arrest and transfer,
whether
those
someone has
requests
been
started going
victim
out
of
as early as the end of
internationally wrongful
December
of
2021,
law, in this case extraordinary rendition,
and was
sanctions,
getting no response.
finally diplomatic
That was
protection
new.
are all
There was no
options that are
we,
available as
the
escalation
interactions.
when the expressions of
Main-
concern, the note verbal, the lobbying has not worked. And in
Face
my
to
respectful
face.
submission, reaching a
And
concluded
then
view,
fairly
clear and
recent.
concluded view, as opposed to a non-provisional view, is a critical component of properly
from
considering those
Nigeria
options and
Okay.
could make a difference.
We're not told either
So
what
can I turn now to the grounds of appeal?
the
And the first ground,
Ms Kilwood, just
Yes.
before you do, can I just,
nor
it's just
what
talking around this
various
question of the concluded
representatives
view, taking it in stages.
said.
I assume
Well,
you
my-
accept that initially at least,
well, my lord, we are
the Secretary
told
of
that there
State was
wasn't a
entitled to form a
response to
provision.
the questions or allegations that were made about
So-
the transfer, and I'll have to track down the paragraphs
When was it
of Ms
you
Sprouton's
said
statement. But there
that
is
he
no
was
dispute, as
obliged
I understand it, between
come
the
to a
parties,
conclusion?
that there has never been. When the
and
evidence
it's not
clear to me
warranted-
whether this
warrants it.
most
No,
recent
when on
written
your
vow
case,
is
Oh, I see.
was he
a
obliged to
satisfactory
come
answer
to a
the
conclusion?
question.
And then
But
obviously the
until,
follow-up
at least
question is
until that
why?
point, there
This
has
is
never
actually
been a
all temporal.
satisfactory answer
So
from the
I just want to try and
That's from the
understand
Nigerian government, from
what
either
the,
the
what the
Kenyan
case is
government
as
or the
to when
from
and
either the
why
Nigerian or the Kenyan
position
government
would have
to the
shifted.
respondents' questions in relation to the
I mean,
circumstances.
the
first and most obvious answer to
and
that
I
question
will
is
try
not
to- I will
precise
make sure you have the
date.
paragraph numbers in this
I,
statement
of
to that
course,
effect,
accept
or in the
but
evidence,
on
that
that
is
is
our
that in the
understanding.
initial
there has not
days,
been an answer. There's
when
not
an
been
individual has
an
been
explanation given.
detained, and one of the important things about the evidence, a process of investigation has to be
and I haven't
undertaken
taken you through it, but it's
to establish the
it's recorded in the
circumstances in
judgment.
which they've been detained.
Is that the Nigerian
and
government
the lawfulness of their
we
treatment.
do have an affidavit that was submitted by the Nigerian
And in
government
order, I
in
also accept
the Nigerian
indeed,
proceedings,
I
which
assert
that in
effectively
order admits in that
the
period of investigation,
unlawful.
the respondent is quite
was
right
it,
not to positively assert that there was
simply
no
take no
extradition.
action,
There was no need to comply
but to
with any
express
extradition
concerns
treaty
based
according
on
to the Nigerian government,
preliminary
because, Mr. Kanu was
views
said to have
that
jumped
she
bail,
is able, he is
and
able
it
to
was
reach
the Nigerian government's
on the
position
treatment of that
in
individual.
that affidavit that they were therefore
But
entitled
as the evidential picture
go on to
develops,
Kenyan soil and apprehend him and bring him back. Obviously, that is not a
Then
position that
the
is
Secretary of
consistent with
State
any law.
is
The
in my
Kenyan
respectful
government had
submission
also
obliged
put in their
to,
in
as soon as it
their
is possible
evidence,
to do so,
and again I can give you
these
a
references.
clearance. The
Non-provisional.
Kenyan government had also put
And
in
this
their
case,
evidence to proceedings in Kenya.
What happened
that
was
Mr.
that the
Kanu had
Secretary of
entered
State
the country, was
for
recorded as having
many
entered the
months
country through immigration,
requesting explanations,
but there was no
by way
record
of
of
note
having
verbal.
left.
You can see that from
There was
Mr.
no
Sprouton's
extradition.
statement as to what had
They were
happened
not party to any
to
extradition.
Mr.
That's
Kanu.
their
The circumstances
case.
of
That's
his
their
arrest
defence.
and transfer. Those
And what
requests
is
started
the
going out as early as the
appeal
end
to
of
the Supreme Court of that.
December
my lord,
2021.
perhaps
it's not very long,
and was
the
getting
appeal
no
to
response.
the Supreme Court is at
How do
168
we know?
to 192,
The interactions
and it is focused on the
main
jurisdiction issue.
face to face, and then fairly recently, a note verbal from Nigeria to.
Sorry, I've given you
Okay.
the wrong page
we're not
number. It's
told
actually, that's
either
the
what-
start of Mr. Ejimeko's statement. It's page
Well,
185
Nor what
of the bundle.
various representatives of Nigeria said
Well,
at meetings.
Well, my lord, we are told that there wasn't a response to the questions or allegations that were made.
ends
about
at 191.
and I'll have to track down the paragraphs.
And
of
what you'll
Mr.
see
Sprouton's statement,
is
there is
that
no dispute,
what is said
I understand it, between the parties, that until
that there has never been,
to give
and it's not clear to me
an
whether
example
this
of perceived
most
motives of
recent
error on
about
page 186.
is
The
a
court below
satisfactory
relied heavily
answer
on the
to
alleged mode of
questions that have
entry,
been raised. But
brackets,
at least
abduction and
until that
extraordinary
point,
rendition,
there has never been a
in brackets
satisfactory
of the
answer
respondent from Kenya to Nigeria
from
as a
the
basis to
respondent.
hold that the
That's
trial
from the
court
Nigerian
lost its
government,
jurisdiction to
from either
entertain
the
the
Kenyan
charge before it,
government,
even
or
when it
the
is not in contest.
from either the Nigerian
And there
or
is
the
sufficient
Kenyan
evidence in the proof of
to the
evidence
respondent's
contained in the
questions
records
in relation
before
to
the
the
court to show
circumstances
that
of
the
the
respondent was standing
And
trial
I will
without
try
the
to. I
orders
will
of
make
the
sure you have the
trial court
paragraph
jumped
numbers
bail.
in Broughton's statement to that effect, or in.
And then
the
at 3,
evidence, but that
Roman
is
3, the court
our
below erred
understanding.
when it held that the
There has
executive
not
arm of the
been
government must not be
there's
allowed
not
to
been,
benefit from his wrong,
an explanation.
brackets, abduction and
And
extraordinary rendition.
One of the important
of the
things
respondent,
about the evidence that
end
was
brackets, when in
below,
fact, by its judgment,
and I
the
haven't
respondent
taken
was
you
allowed,
through it, but
that's
it's,
Mr. Kanu, to benefit from
recorded in
the
the judgment,
illegality of his
is that the
disobeying
Nigerian
orders of
government,
the court when he jumped
we
bail.
do have an
I should
affidavit that
pause
was
there to say
submitted
that
by
that's
the
why I've
Nigerian government in
pointed out the judgment of the Nigerian court in
proceedings,
January
which effectively
2022.
admits,
He
left
left the country, he was on
that
bail
unlawful
when the
transfer
Nigerian
because it,
military
positively
raided his
asserts
home
that
and
there was
attempted
no
to kill him, according to the
extradition.
Nigerian court.
There was no need
So that's
to
why he
comply with
fled,
any extradition treaty according to
disobeying the
Nigerian
orders of the court when he jumped bail and was
because,
rewarded with a
Mr. Kanu
discharge
was
from the
said to
charges
have
pending
jumped bail.
against him at the trial court,
And
thereby
it was the Nigerian
occasioning a
government's
miscarriage of
position
justice against the state and the
that
matters
affidavit that they
of
were
the
therefore
crimes.
entitled.
And you know, the same point
to
is
go
made
on
in
to
a number of
Kenyan
different
soil
ways.
and
And you can
apprehend
see a
them and bring them
similar
back.
point made
Obviously, that is not a position
at
that's
ground
consistent with any
3.
law. And the Kenyan government had also put in their evidence, and again, I can give you these references.
I appreciate
The
your
Kenyan
case
government
is
had
always
also put in
responsive.
their evidence to proceedings in Kenya.
At the moment,
That Mr.
I'm
Kanu had
looking
entered
at
the
what
country,
the grounds
was
of
recorded
appeal
as having
are.
entered the
It
country
doesn't
through immigration,
seem to me, looking
but there was no record of him
these
having left.
grounds, that
And there was no extradition.
they involve an
They
admission
were not
of
party to any extradition.
illegal
That's their
behaviour
case. That's their
on the part
defence.
of the government. In what,
Well,
what
my
is
lord,
the
they do.
appeal
They
to
don't
the Supreme
challenge
Court?
the conclusion. Well, my lord, of the
Perhaps
Court
it's not
of
very
Appeal
long. The appeal
that
to the Supreme
transferring
Court is at 168
the
to 192.
Mr. Kanu from Kenya to Nigeria,
And it is focused
on the
jurisdiction issue.
in the absence of an extradition, an order for extradition was amounted to an extraordinary rendition. And the Court of Appeal in its judgment went through both domestic law, in a local
Sorry,
human
I've
rights
given you
law,
the wrong
the
page number. It's
Africa-wide,
actually, that's the start
and
of Mr.
international. It looked at
Ejimakula's
Bentley, for
statement.
example,
It's page
looking at the,
185.
House of Lords decision in that case.
No, I understand that, but
So these are not challenged.
ground 3 at the bottom
Yes.
of page 187 says the court below occasioned a miscarriage of justice
And it
when it
ends at
held that the
191.
rendition of the respondent is unlawful.
And what you're seeing is that
Yes,
what is
well,
said,
My lord, that case is about a domestic
principle,
particular
Patrick
error
Evans
and
and
others
others
is
is
about
about
the court below
domestic
relied heavily
transfer
on the
across
alleged
states
mode of
entry.
Nigeria, as I understand
brackets,
abduction
so
and extraordinary rendition.
it's the
In brackets,
international
the
law
respondent from
finding.
Kenya to Nigeria as a basis
These are all
to hold that the
domestic
trial
law
court had
arguments
lost
about the
jurisdiction to
consequences for
entertain the
criminal,
charge before it, even when it is not in
charges
contest.
of
And there is sufficient
this
evidence in the proof of
international
evidence
law
contained in the
law.
records of appeal before the court
That's
to
what
show
the-
that the
this-
respondent was
this-
standing
this
trial
appeal
and
is
flouted
about.
the orders of the trial court and jumped bail. And so that is why, and then at 3, Roman 3, the
And
court below
what's
erred when it
more,
held that the
if your
executive arm of the
lordships
government must
look
not
at
be
the
allowed to
judgment
benefit
of the
from his
Nigerian
wrong,
Court of Appeal,
brackets, abduction and extraordinary
and it may be
rendition,
worth having
the respondent, end brackets, when in
a
fact,
brief
by its judgment,
peruse of some
the
of its
respondent was
conclusions.
allowed
The
as
point
Mr. Kanu
is
to
that
benefit
in
from
those
the
proceedings there
illegality
was
of
no
his
evidence
disobeying the orders of the court
proper
when he
evidence
jumped bail.
dealing
And I should
with the
pause there to
extradition.
say that that's
In
why
those particular proceedings,
pointed out the
the
judgment
affidavit
of
I
the
referred
Nigerian
to is
court
in
in
another
January
proceeding.
2022.
And so what the
He
court found
left the country.
is that
He
there
was
were
on bail
there was no
when the Nigerian military
proper denial
raided his home and
of
attempted to kill
the
him, according to
allegation
the
of
Nigerian
extraordinary
court.
rendition.
So that's
This
why
is going
he
on
fled.
appeal to this
Disobeying the
Supreme
orders
Court.
of the
It's
court
not-
when
there
he
isn't
jumped bail
going
and was
to be
rewarded with
any
a discharge
further
from the
evidence,
charges pending against him at
in
the
the
trial
Supreme
court, thereby
Court
occasioning
in
a
relation
miscarriage
to
of
the
justice against the
extraordinary
state and
rendition.
victims
So, my lords,
of the crimes.
the basic
And
point
the same
is
point is made
that
in
the
a number of
evidential
different ways.
picture is not going to change.
And you can see a similar point
the
made.
Nigerian courts of various
At ground 3,
views, as recorded in the judgment below, have all found that this amounts to an extraordinary rendition. There is, I accept, that's why the appeal,
All this is
there has been a stay on the appeal.
At the moment,
There is, I accept, a
I'm
possibility
looking at what
that the
the grounds
Nigerian
of
court may
appeal
find,
Yes.
notwithstanding, the Supreme
seem
Court
to
may
me,
find, notwithstanding this serious breach of
these
international
grounds,
law,
they,
that Mr. Kanu can go on to be
they
tried
involve an
for
admission
charges that carry
illegal
the death
behaviour
penalty, which is what
on the
he's
part
facing.
of the government.
But that would not be
my lord, there are
a
they
reason for the
they don't challenge
Secretary of
the
State not
conclusion
to
of
reach
the
a concluded
Court
view
of
on whether there's
Appeal
been an extraordinary rendition.
that transferring
Indeed, that would be a reason
for reaching such a view,
because
Mr. Kanu,
from Kenya
as far
to
from an
Nigeria,
international law perspective, as the Nigerian court itself found,
in the absence of an
an
extradition,
extraordinary rendition
an order for
invalidated
extradition,
such
amounted to an extraordinary rendition
and
would
would
render
Court of
any
Appeal in its judgment went through
implementation
both the respondent
domestic
accepted it
law,
or widely,
in a
of
local
the death penalty,
human rights
particularly
law,
egregiously
so,
Africa-wide.
my lords, we still come back
And
in my
international
international
submissions
look at
to
the same
Bentley,
point,
for example,
which
looking at
is
the,
that
House of
the
Lords
evidential picture
decision in
now,
that case.
2 years after
No,
Mr. Kanu
I understand
was
that,
detained.
but
So these are not challenged
ground
after
3 at the bottom
yes,
of page 1.
multiple requests for further
As
information.
the court
from the
below
Nigerian
occasioned a miscarriage of justice when it
after
held
the
that the rendition
United
from
Nations
on law.
Working Group on Arbitrary Detention has itself
Yes,
expressed
well,
a view.
My
That's
lord,
recorded in the judgment
that
as well.
case is about
Has
domestic,
itself expressed a view that
Mr.
Principal
Kanu
has been the
Patrick
victim of
Gibbons and
extraordinary
others is about a
rendition.
domestic
That's
transfer across
in the
states
bundle,
in Nigeria,
supplementary
as I
bundle at
understand
pages
it.
507 to
This is
523.
the international
That's the UN
law
working
finding
group on arbitrary
These are all
detention.
domestic law arguments about
And
the
when the
consequences
Nigerian
for
criminals
criminal
have reached that view on the evidence before them.
charges,
and
of
there is no further
this
possibility of
international
any
law
further
law.
material emerging
that's what this
on that question
this
of whether
appeal is
he's
about.
been extraordinarily rendered.
And so
because the
that is
position
why
is so clear.
and
There is
what's
no
more,
reason, if your lordships
for
look
the
at the judgment of the
respondent's
Nigerian
view,
Court of Appeal, to remain provisional.
and it may be
in
worth
short,
having a
in colloquial language,
a
what
brief
is the
peruse of some of
respondent
its key
waiting for?
conclusions. The point is
What
that
is
in
going-
those
what does the
proceedings
respondent
there was no
expect to
evidence
emerge proper
as a
evidence
result
of dealing with the extradition
future proceedings,
which
which
is
is
going
going
to change the
proceedings.
position. The affidavit I
Indeed,
referred to
that's
is one
one
of
of
the
the
questions
questions
that is raised
so
by
what
ground
the
three
court
found is that there was
no
proper
no,
explanation of what it is,
proper
that the
denial
respondent is waiting
of
the
there isn't going
allegation
to
of
be any
extraordinary
evolution of
rendition.
any evidence.
Now, this is going on
on the
appeal
critical question
to the Supreme
of
Court
whether
whether
there was
there isn't going to be any further
Yes,
evidence.
there is
going to
in
be
the
an
Supreme
evolution
Court as to whether
in
the
relation
Court
to
of
the
Appeals
extraordinary
will
rendition. The criminal
So,
charges
my lords,
will be
the
up.
basic point
But
is
not on anything
that
else.
the evidential picture is not going to change.
And in any event, it's
the
not
necessary,
Nigerian courts
even
of
if there,
various
even if there had been a
views, as
challenge
recorded in the judgment below, have
to
all
the
found
to the findings
this
of
amounts to an extraordinary
rendition
rendition.
as a matter of international law.
There is, I accept,
it would not be
a
necessary
that's
to
why the
wait
appeal,
unless there was a good reason
there
to
has been a
suspect
stay
that
on the
something
appeal.
new was going
There
to
is, I
emerge.
accept, a
The
possibility
government could have
that the
lodged an
Nigerian
entirely
court may
spurious
find,
appeal
notwithstanding,
to,
the Supreme Court may
against
find,
the
notwithstanding this
findings.
serious breach of international
and
law,
in those circumstances,
that
it would still
Mr.
be
Kanu
necessary
can go
in
on
that
to be
position.
tried,
Not in that
for
position, but
charges
it would
that
still be
carry
necessary
the death
in the
penalty,
central
which is what he's facing
himself.
But that would
on
not be
material.
a reason
Why? Because
for
a
the
British citizen
Secretary of State
been
not to
the
reach a
victim
concluded
of a
view on whether
serious
there's been an extraordinary
one of the
rendition.
most serious breaches.
Indeed,
that
that would be
there
a
can
reason
be
for
reaching
to
to
be
be
abducted
abducted in a
because
foreign country
if
and
the transfer
transferred from an international
violently
perspective
over
as
a
the
border
Nigerian
and then
court
charged
itself
with a
found,
death penalty,
an
an
extraordinary
extraordinary
where that
rendition
foreign government could have
invalidate
sought extradition by
such
lawful means.
what
actions
more
and
serious
would render any
breach could there be
implementation, even
of a
if the
British
respondent
citizen's
accepted it more widely,
of the death
he's been
penalty,
kidnapped,
particularly egregiously unlawful.
and
We are
So,
now at the
my
position
lords,
we still
is
come back
where
in
it
my
is
respectful
necessary,
submission
in my
to the same point and which is
and
that
the
evidential
evidential
picture now,
2
given the
years
state of
after
the evidence, Mr. Kanu
for the Secretary of
was
State to
detained,
come off the fence
and
reach
first
a conclusion
detained after
what has
multiple requests for further
happened.
information.
And my lords, could I now turn to Abbasi
Yes.
on ground one? Because
After
in
the
my
U-
submission, it's
United
United Nations
before you do, my Lord asked the
Working Group on
question
Arbitrary
of
Detention
when.
has itself expressed a view.
And you said
That's
as the
recorded in the
evidential
judgment
picture
as well.
develops, the Secretary of State
Has itself
applies
expressed a
as soon
view
as
that
possible,
Mr. Kanu has been the victim of
to
extraordinary
reach a
rendition.
non-provisional view.
That's in the
Presumably,
bundle,
on the basis
supplementary
of
bundle at
decisions
pages
you challenge
507 to
dated
523.
April and June of
That's the
2022.
UN Working Group on Arbitrary
That's the
Detention.
date on which he should have
And
reached
when
his
the
non-provisional
Nigerian
view.
courts have reached that
Well,
view on the evidence,
Yes, so
She at that
and there is no
time.
further
Yes, well,
possibility
there
of
is-
any
there is-
further material
Yeah.
emerging
on that
question of whether
well, it was
he's
the
been
it was the
extraordinarily
appellant's position
rendered,
because
position is
what
so
the
clear.
appellant did prior to
there is
the
no
decision of the
reason
14th of
April
for these
is to send
respondents' view
the
to
to
remain
remain a
provisional.
range of evidence.
I mean, in
about
short,
what has happened,
in colloquial
including
language,
evidence
what
that
is
he
the
had
respondent
gathered
waiting
about
for?
flight paths and
What
so on.
is
And all
going?
of this
What
is
does the
explained
respondent expect
in
to
the witness
emerge
statement of Ms. Mark
as a result of
the first witness statement put in with the
future proceedings, which is going to
showing
change
that
their
there had
position?
that
Indeed,
the
that's one of
evidence
the
show-
questions
demonstrates
that is raised
there
by
had been
ground
an
3.
rendition. In other words, a
There is
rendition
no
without any
proper
law
explanation
process,
of what it
a
is
secret
that the
right,
respondent
and
is
so on.
waiting for. There isn't
So
going
that
to be
was
an evolution
the
of
position
any
at
evidence
which,
on the critical question
brought
of whether there was an extraordinary
challenge. But
rendition.
obviously, this is an
Yes,
ongoing
there is
challenge.
going to be an evolution as to whether the
whether or
Court of
not
Appeals
this
conclusion
court,
quashing the
the
criminal
court
charges
below, felt
will be
that
upheld.
that point
But
had been
not
reached
on anything else
in
April 2023.
And in any
Um,
event,
is
it's not
necessary.
Sorry,
even
in
if there,
April
even if there had been a
2022,
challenge, the position has
continued
continued
to
the findings of
to change.
extraordinary
And
rendition as a
the
matter of
United
international
Nations
law.
Working Group
It would not be
report,
necessary to wait
unless there was a
United
good
Nations
reason to
Working Group
suspect
on
that
Arbitrary
something
Detention's
new was
report,
going to emerge.
emerged in
The government could have
August
lodged an
to-
entirely
sorry,
spurious
late
appeal
July
into
2022,
the,
and
against
then
the
these judgments
findings.
in
And
October.
in those circumstances, it would still
And
be
it is the
necessary,
appellant's
in my
position
position,
that not in
whether
their
or
position,
not
but
it would
that,
still be necessary for the Secretary of State to reach a conclusion.
the evidence permitted it
himself
in
on the
April, which
material.
it, and that is
Why? Because a British citizen
the appellant's
been,
pleaded claim.
the
It
victim
certainly
of a
does now.
serious breach of international law, one of the most
And what we
serious
see
breaches, that
is there
that
can be,
notwithstanding
which is to be
those
adopted
changes
in a
that
foreign
we-
country
and
and
the clarity of the position that we've
transferred
reached now,
violently over
the Secretary of
a
State
border
continues
and
to
then charged
maintain
with a
provisional
death
view.
penalty in circumstances
And
where
the
that
reasoning
foreign
that
government
is
could have
given
sought extradition by law
appears to be
I mean, what
more
more
serious
because
breach
he has
decided
of a
not
British citizen's right
to take action.
it's not necessary
Necessary
kidnapped and
And in my
we are
respectful
now at the
submission,
position
that cannot
2
possibly
years on
be
where
right.
it is necessary
in my respectful submission.
it is and
The
a first
logical step
obligatory
where I began is
given the state of the evidence
was the
for the Secretary of
victim
State to come off the
extraordinary
fence
rendition
and reach a
and
conclusion.
if so,
about
what steps
What has happened?
to take.
And my lords, could I now turn
is
to
important
back
now to look
Yes.
at ground one?
because
Just-
in my submission it's clear
Just
Yes,
before you
to
do,
see
my Lord
where,
asked the question, well, when?
that argument
And you said, as the evidential
comes
picture develops, the Secretary of State is obliged as soon as possible to reach a non-provisional view. Presumably,
That's why I
Yes,
think
at
the
tab
basis
8.
bit,
decision has been
I
challenged
understand the
dated
difference between
April and June of
included
2022.
view and a provision.
That's the date on which he should have reached his
You've
non-provisional
at
view.
some time,
Well, yes.
some
So
point,
That's she at that time, I suppose. I can't remember.
yes. Well,
referred to
there
a
is
included
has been
view.
a change.
Yeah.
come to a clear view.
Yes. Well, it was
Sometimes
the
to a
it was
formula.
the appellant's position.
Yes.
Is there any difference?
Because what the appellant
between
did
that?
prior to
I
the
would have
decision
said-
of the 14th of April
Clearly,
is
a
to send,
provisional view is different from a
the
final.
respondent a
Yes.
range of
Final
evidence about what
strict
had happened,
included.
including
But
evidence
is there
that
any
he
is
had gathered
formulated
about
view something different?
flight paths.
the
and so
formulated
on, and
views
all of
we'll
this
see is
explained
language that was
in the
used
witness
in
statement
Bassett.
of Ms.
What does it
Marker.
mean?
the first witness statement
Formulated view
proceedings,
might be.
showing that there had
It's
that
too
the
early
evidence
to say.
demonstrated there had been an
the
extraordinary
formulated
in other
view
words,
on whether someone
rendition
has been
without
convicted
any
of
lawful
as we will
process,
see, that's the
seek context
light
in
and
which
so
the
on.
language is used in Bassi.
So
that
was
was
formulated
the
view
position
as to
at
whether
which,
someone has
the
been,
subjected
to a breach
his
of
initial
international
challenge.
law.
But obviously this is an
That's the
ongoing
way it's put.
But I mean, the simple answer
So,
to your question is
there's
whether
not
or
intended
not
to be a
this
court or
really
court
what
below
all of
felt
those
that
terms are
point
supposed
had
to
been
do is
in
provide an
April
opposition. It's really
2023,
not a provisional view.
Is-
It's a way of saying not
in
a
April
provisional view,
in
not
April
preliminary,
So you
not
say
to.
formulated
The position
can't be a
has
provisional view.
continued to
I
change
say
in the
and
context in
the
which the
United
United Nations
look
Working
at
Group
Bassi,
formulated
can't
report,
be provisional.
the United Nations Working Group on Arbitrary Detentions report emerged in August, in the late
Right,
July
let's look at
2022,
Bassi.
and then these judgments in October 2022. And it is the appellant's position that whether or not
so Bassi is at tab 8.
The evidence
in
permitted
the
it.
authorities manual that starts at
April,
authorities
and that
292.
is the appellant's pleaded claim. It certainly does now. And what we see is that, notwithstanding those changes that and the clarity
My
of the
lords,
position that we have reached
without
now, going back to it, the Secretary of State continues to maintain the case of GCHQ, and the reasoning that is given at bundle at tab 2 appears to be, and that because he has decided not explains in to take action. It's not necessary thought that the exercise of prerogative powers like the one, and in my respect, being exercised in this case was not amenable to judicial review. But the House of Lords in that case, first logical step, and this is in the various speeches, but was the individual Scarman's speech, extraordinary rendition, 407, and if so, what steps 99 to take authorities bundle. And my lord, I think is that the controlling factor to look at Bassi in determining whether the exercise of prerogative power is subject to judicial review is not its source, but its subject matter. Comes, and since that point, the position has been that if the subject matter or factual application of the power is suitable for review, prerogative
That's why
powers
I
are
think
tab
it's
8
very,
on the grounds
I
of
understand the
illegality,
difference between
irrationality,
included
procedural
and a provisional.
propriety, and that's your Diplock speech.
You've at
at
some time,
10C to F.
some points,
Now, because Lord
included view,
Roskell
some
in
clear
GCHQ
view,
had identified a series
sometimes
of
to a
prerogative
formulated
powers
view.
which he
Is
thought
there
were
any
not
difference
susceptible to judicial
between that?
review,
I
and
I
listing
would
the
have
making
said-
of treaties, the defence of the realm,
clearly, a
the
provisional
prerogative
view is
of
different from a
mercy and the
final,
grant of honours.
Yes.
And
final
some of the
straight
examples.
concluded.
Um,
But is there any, is
chance,
formulated view something
the
different?
courts the formulated views we'll see is naturally see a series of challenges in
What does it
which
mean?
all of these suggestions of
Formulated
potential
view might
immunity
be,
have been
Um,
explored and refined.
It's too early to say.
And one of those judgments, the formulated view on whether someone has been convicted,
and
of
we
it. As
can
we will
see,
see, that's the
the
context
court
in which
applying
the
the
GCHQ approach, and also
It's a
another
formulated
view
view
as to whether
ever
someone has been at paragraphs 81
subject to
onwards. So it's gravity. That's the way it's put. But I mean, the simple answer to your question is there's not intended
And
to
it's
be a
at
difference.
280.
Really, what
Bundle.
all of those terms are supposed to do is provide an opposition. It's really not a provisional view. It's a way
and
of saying not a provisional.
Could I just
view, not
ask you
preliminary.
first,
When you
Not
say
to
formulated
delve
can't be a
further
provisional
into it,
view.
to look at
I
paragraph
say
80
in the context in which we
and
look at
what the court
Bassi,
said there in the sidelined
formulated
passage
provisional.
is that there are three considerations which have led us to reject the proposition that there is no scope for judicial review of a refusal to
Right,
render
let's look
diplomatic
at that.
assistance to a British subject who is suffering violation of a fundamental human right as the result of the conduct of the authorities of a foreign state.
So Bassi is at tab 8.
The
authorities
first
bundle
starts at authorities.
the
252.
source
of all of this jurisdiction and expectation is the suffering of a violation of a fundamental human right. And the court gives the first consideration, which is the
my
development
lords,
in the law in GCHQ.
without going back to it,
the doctrine of legitimate expectation
is in the bundle at tab 2,
and then at 85
the court explains in Abassi,
the court
until
says
that
those
case, it was thought that
referring
the
to
exercise of
extra powers like just alluded to
being
myself
exercised in this case was
GCHQ.
not amenable
These extracts
to
indicate the issue of
judicial
justiciability depends not on
but the
general
House of Lords in
principle,
that case,
but on subject matter and suitability in the particular
and this is
case.
in this various
That is
speeches
illustrated by the subsequent
encapsulated
case
in Lord
of
Scarman's
Everett,
speech, 407,
which concerned a decision not to
which
issue
is
a page
passport
99
of the authorities bundle.
Lord Justice
is
Taylor
that the
summarised the
controlling
effect of the
factor
GCHQ case
in determining whether the exercise of
ousted
power
merely
is
by
subject
working
to
in
judicial
work,
review is not
invoking the word
source,
prerogative,
but it's
so
subject
you
to
can't
matter.
just raise the flag.
And since
then
that
the courts will
point,
look
the
away.
position has been that if the subject
and
matter or
then,
factual
the
application of the
court
power is suitable for
showed
review,
in that
prerogative
paragraph
powers are
what I
reviewable
say is a
on
now
common
a
law
consistent
grounds
theme
of
across the
illegality,
case law.
irrationality,
See in the quote
and
from,
procedural
85
propriety.
that there is a careful
Different
examination of
speech
whether the issue in
410
fact
C
engages
F.
the
Now,
subject
because
matter is said to be
Lord
non-justiciable
Gospel in
or not.
GCHQ had identified a series
And
of
in that
prerogative
case,
powers
the court
which he
found
thought might not be
that
susceptible to
the grant or
judicial
refusal of
review,
a passport raises
and
issues
listing the
which
making
are
of
just as
treaties, the defence of the realm,
as, for
the
example, the
prerogative
issues arising in
of mercy and the
cases.
grant of honours, as some of the examples.
And then the second consideration which led them to conclude
chance,
that the
the
matter was
courts have
reviewable is at paragraph
naturally
87,
seen a
and
series
that
of
is the
challenges
policy
in which all of these suggestions
capable of giving
potential
rise to
immunity
legitimate
have been
expectation.
explored and refined. And one of those judgments is
And
Bassi, and
the
we can
court
see
goes through
the court applying
various
the GCHQ
passages
approach and also
in
another
the policy and
case
statements
of Everett at
in
paragraphs
Parliament
81
91,
onwards.
and then summarises the and it's at 280. At 91, you'll see in the quote from the parliamentary answer from Baroness Scotland at the end in the italicised words. The UK government would also
could I just
consider
ask
making
you
direct
first,
representations to
before
third
we
governments on
delve
behalf of
further
British
into
citizens
it,
where we
to
believe they were
look at
breaching
paragraph
international
80
obligations. Paragraph
And
92.
what the
Taken
court said
together,
there
these
in the
statements
sidelined
indicate a clear
passage
acceptance by the government
is that
of
there
the
are
role,
three considerations
in relation
which
to
have led
protecting
us
the rights
to
of
reject the
citizens abroad,
proposition
where there is evidence
that there is no
of miscarriage
scope
or
for
denial of
judicial
justice,
review
of a refusal to render diplomatic assistance to a British subject who is suffering violation of a fundamental human right as the result of the conduct of the authorities of a foreign state. So, the first,
citizen may have suffered
the source of all of these, of this jurisdiction, and expectation is the suffering of the violation of a fundamental human right. And the court gives the first consideration, which is the development in the law in
Well, that's right, my lord, but I don't think it's being suggested that that the expectation does not arise even when that is happening. And one of the reasons for that is you'll see from the ministerial submission.
And then at 85,
the 1st July 2021 ministerial submission is that
court
the
says those
expectation
referring to the
of
extracts
the
which I
respondent
just
was in
alluded
fact
to
that the
myself in GCHQ,
local courts in
these
Nigeria would
extracts
not
indicate the issue of
provide
justice
a fair
depends not on general principle, but on subject matter and suitability in the particular case. That is illustrated by the subsequent case of Everett, which concerned a decision not to issue a passport.
in this
Lord
case,
Justice Taylor summarised the effect of the GCHQ cases, making clear that powers straight away ousted merely by invoking the word
you'll see
prerogative.
at page
So you
1
can't just
130.
raise the flag, and then the courts will look away.
Paragraph 6, given the political context and pressure from the
then
executive,
the court
we do not expect a
showed
trial.
in that paragraph,
Schedule
which I
is a
say is
supplementary
now a
bundle.
consistent
Schedule
theme
for
across the
26th to 27th
see
July
in the
to be
quote
free
from,
and fair.
at 85,
That there is a careful examination of whether the issue in fact
engages
that
the
only
subject matter
highlights
is said to
the-
be non-justiciable or not.
the importance
And
of
in
the
that
judgments
case,
were in fact
the
reached,
court found
despite all that pressure.
That
and political
the grant or
context,
refusal
they
of a passport
nonetheless
raises issues which are
found
just as
these
as, for
particular
example,
courts
the
nonetheless
issues arising in
found that
immigration
there'd been an extraordinary
cases.
rendition
And then
It's
the
not
second
the general
consideration which
expectation
led
as
them to
this
conclude that
submission
the matter was
clear
reviewable is at paragraph 87,
proceedings as a
and
whole,
that is the
and that
policy to include what capable of giving rise to a legitimate expectation will be free and fair given the political context and the pressure. And so, of course, the
by way of
court goes through
Would you,
various passages in the policy and statements in Parliament 91, and then summarises
you're
the.
cake and eating it. I mean, speaking for myself, it seems
And
very
at 91, you'll see in the quote from the
powerful
parliamentary answer from Baroness
from
Scotland,
your clients
at the
very
end
clear
in the
that
italicised
a succession of courts,
words, the UK government
including
would also
Nigeria,
consider making direct
will
representations to
found in
third
its
governments on
favour.
behalf of British
Very
citizens where we
emphatic
believe
term.
they were in breach of their
Yes.
international
and if the
obligations.
Supreme Court were
Paragraph
to do the
92.
same,
Taken together, these statements indicate a clear acceptance
the
by the government of a role
case
in
for
relation to protecting the rights of
for
British citizens abroad, where there is
respecting
evidence of miscarriage or
the
denial of
Nigerian
justice.
authorities to
Yes.
abide by the judgment might be overwhelming. But your Baroness Scotland's, you're now saying, well, state, it's legitimate, say, in cases where British citizens may have suffered, the Secretary of State should have borne in mind that the most appropriate course officials don't expect take action through their in court. Trial to be free and fair.
My lord, it's not should have. They have borne it in mind, and it's obviously continues to be relevant.
Well, that's
And
right.
I
my
don't.
lord, but
I don't think it's
having
being
a-
suggested that
obviously
that the
when a
expectation does not
court,
arise,
even
even when that is happening.
despite
one of the reasons
enormous
for that,
political pressure,
as you'll see from the ministerial
finds in
submission,
favour of an individual.
the 1st
That doesn't
July
mean there hasn't been
2021
political pressure.
ministerial
it means that
submission
despite the political
is
pressure,
that the expectation
it has
of
nonetheless
the
found
respondent was in
favour
fact
of
that the
individual.
local
But
courts in
obviously
Nigeria would
that
not
political pressure
provide a fair outcome
remains,
in
on
in
these
this
appeal
case.
proceedings. And that's the judgment that the respondent has set out in the evidence before this
I'll
court.
give you the reference for that because it's clearly important.
There's no other judgment.
Why does that
That's why
mean that
in this case
Secretary of State
submissions and concerns were
obliged
raised
to
straight away.
reach a concluded view?
You'll
on,
see at page 1, it's 130.
Mr. Kanu
Paragraph 6, given the political context and pressure from the executive,
unlawfully
we do not expect the trial.
Well, my lord, because
Schedule,
the
this is
Secretary of State's obligation to
Schedule
reach
for
a
26
conclusion
to 27
is not
July to be
dependent
free and fair.
on other courts. Her own internal,
Now, of
included
course,
view. It's dependent on
only
whether she is
highlights
able to make that
um,
assessment based on the evidence.
the importance of the judgments
Part
which
of
were
the
in fact
evidence
reached, despite
is
all
the
that
judgments
pressure and political
of
context, they nonetheless
of
found
the courts of a foreign country.
these particular courts
That's
nonetheless
evidence.
found that there'd been an extraordinary rendition.
But it's not the only
But
evidence.
and
not
a
a general
judgment of a foreign
expectation.
country may find that there
submission
hasn't been an extraordinary
makes
rendition
clear for all sorts of
that,
reasons.
the proceedings
The
as a
Secretary of
whole
State, for example,
may
in the Natsneen
radically
case,
include
would
what
not
happened in the Supreme
rely
Court,
on the conclusions
will be
of
free and fair given the political
an Iranian
context and the
court,
pressure.
because its judgment
So of course,
would have been
by way of
that
example,
Iranian courts were the result of political pressure and unreliable. But those conclusions would have been relevant evidence on some question or
having
another.
your cake and eating.
And so
I mean,
my argument in relation to the Secretary
Speaking
of
for
State's
myself, it seems a
requirement
very
to reach a concluded or clear view
powerful
and non-provisional
fact
view is
in
that
your client's
that is
favour
what is required
that
as a
the
matter of logic and
succession of courts,
also as a matter of legitimate
including the
expectation
Nigerian court,
by Abassi and the
found in
passages
its
that we're
favour.
going to look at.
Very emphatic term.
But it is also required because
And if
the
Supreme
evidence
Court were to
has
do
now
the
got
same,
to a stage where no other reasonable
the
conclusion is possible. That's ground
case
two.
for expecting the Nigerian authorities to abide by the judgment might be overwhelming. But you're now saying, well, it's a legitimate factor that the Secretary of State should have borne in mind that his official
And so the court in Abbasi at 283, paragraph 92,
trial to give free
summarises the position.
My lord, it's not should have. They have borne it in mind.
Clear
Obviously
acceptance
continues to
by the
develop.
government of a role
And
in
I
relation
don't
to
accept that
protecting
it's
the
having
rights
my
of British citizens
Ob-
abroad,
obviously,
where there is evidence
when
of
a
miscarriage or denial
court
of justice.
even
The
despite
words
the
emphasised
enormous
contain
political pressure,
no more than a
finds in
commitment to
favour of an
consider making
individual.
representation.
that doesn't mean there
which will
hasn't
be
been
triggered by the
political pressure.
belief
It means
that
that
there is a
despite
breach of the
political
international
pressure,
obligations.
it has
This seems to imply that
nonetheless
such
found
consideration
in
will at
favour
least
of
start
that
from a
individual.
formulated view
but obviously
as to whether there
that
is such
political
a breach
pressure
and
remains
as to the gravity of the resulting
on
denial
these
of
appeal
rights.
proceedings, and that's the judgment that the respondent
and then
set out in the evidence before this court.
The court
There's no
Why-
other
goes on
why
at
did-
paragraph
why does that
98
mean that the
on the next
Secretary of
page.
State was
These statements reflect the fact that, to use the words of Everett, it must be a normal expectation of every citizen that if subjected abroad to a violation of a fundamental right, and I say again, it's a necessary prerequisite that there is a judgment about whether that has happened.
My lord, because
The British government will
Secretary of
not
State's
simply wash their
obligation
hands
to
of the
reach a
matter
concluded
and
view
abandon
is
him
not
to his fate.
dependent
On and then at paragraph
other courts.
99, this is an important
her own
passage.
internal.
At paragraphs 99 to 100.
It's
rather than read
dependent
them
on
out,
whether
could I ask
she is
to read those
able
passages.
to make that assessment
Ms.
based
Gilroy,
on the
just as a
evidence.
matter of the structure of this,
Part of the
this
evidence
judgment,
is the judgments
Lord Phillips said
of
at the paragraph you showed us
of the
80,
courts of a foreign
there are three
country.
considerations.
Yes, it's evidence.
And the first is the development
But it's
of the
not
law,
the only
which you've taken us to.
Yes.
And
The second
the
is,
judgment of a
was there a
foreign
policy,
country may
which is
find
paragraph
there
87,
hasn't been an
which I
extraordinary
get.
condition for all sorts of
What's the
reasons.
third?
The Secretary of
the
State,
third
for example,
consideration
in the Radcliffe case,
is,
would not rely on the conclusions of an Iranian
is the
court.
normal expectation of
Because
this is what we're
its
dealing
judgment
with.
would have been
The
that
normal
Iranian
expectation of
courts
every citizen
were the result of
that
political
if subjected
pressure and
abroad to
unreliable.
a violation
But those conclusions
of,
would have been relevant evidence on some
of a
question or
fundamental
another.
right, the British government will not
And so
simply wash their
my
hands.
argument in relation to the Secretary of State's requirement to reach a
I'm just trying to
concluded
find
or
where-
clear view and non-provisional
Yes, you can see
view
that
is
from
that
paragraph 95.
that is what is
We shall
required
revert to the extent
as
of
a
any
matter of
legitimate
logic
expectation in a
and
case such
also
as
as a matter of
his.
legitimate
Thank you.
After we have
interpretation
referred to the
from
third
Bassey and the
consideration.
passages that we're going to look at.
Just
Yes, it is
tidy
a way
mind.
I understand
My
it,
tidy
because the
mind.
It took
evidence
me a while to
has now got to a stage
Thank you very much.
where no other reasonable conclusion is possible. That's ground two.
So that's the third consideration, and then it's
Yeah.
paragraphs 99 to 100.
sorry, what's the third?
What's the
The third consideration is
Which weighs in favour of the possibility of judicial review.
Yeah.
That's at end of paragraph 95. So the first consideration was the reviewability of prerogative
powers.
Abbasi at 283.
The second
paragraph 92,
consideration was the
summarises
legitimate
the
expectation
position.
engendered by
clear
policy
acceptance
statements.
by the government of a role in relation
And the
to
third
protecting the rights of
consideration
British
was
citizens
an
abroad,
additional
where there is
legitimate
evidence of miscarriage or
expectation.
denial of
And
justice.
that's the one at 98, read together.
The words
with
emphasise
95. So
contain
it's not rooted
no
in
more
policy
than
statements.
a
it's
commitment
in
to
the normal
consider making
expectation.
representations, which will be triggered by the belief that there is a breach of the international obligations. This seems to imply that such consideration will at least start from a formulated view as to whether there is such a breach and as to the gravity of the resulting denial of rights. And then the court goes on at paragraph 98 on the next page. These statements reflect the fact that, to use the words of Everett, it must be a normal expectation of every citizen that if subjected abroad to a violation of a fundamental right, and I say again, it's a necessary prerequisite that there is a judgment about whether that has happened, the British government will not simply wash their hands of the matter and abandon him to his fate. And then at paragraph 99, this is an important passage.
Yes.
At paragraphs 99 to 100, rather than read
so
them
you
out,
can
could I
see
ask
there
you
that
to
read those passages.
that there is a balance
Ms. Kilward, just
Yes.
as a matter of the structure of this judgment,
between the
Lord
request
Phillips said at
and the
paragraph you
foreign
showed us
policy
80,
considerations.
there are three considerations.
Yes, and at
And the
100,
first is the development of the law, which
one
you've taken
vital
us to.
factor. Yes.
The second is,
That
was
is
there a
one
policy,
of the
which is
vital factors
paragraph
to be thrown into
37,
the balance,
which
as
I
the
get.
policy recognises,
What's the
is the
third?
nature and extent of the
the
injustice
third
which he claims to
consideration
have suffered. It is, and then the court goes on to say, even where there has been a gross miscarriage of justice,
it is the normal expectation.
there may perhaps be
this is
overriding
what we're
reasons
dealing
of foreign
we're
policy
dealing with.
which may lead the Secretary of State
the
to
normal
decline
expectation of
to
every
intervene.
citizen.
However, unless and
that
until
if
he
he
objects
objects
to
to
a
a
judgment
violation
as to the gravity of the
of,
miscarriage, it is impossible for that balance to be properly
of a fundamental
conducted.
right. The British government will not simply
And in my
wash their
respectful
hands of.
submission, when you look through all of those passages,
Yes,
you
can
can
see
see that from paragraph 92. We shall revert to the extent of any
90,
legitimate expectation in a case such as
8,
this, as his.
Thank you.
After
And
we have referred to the
100,
third, it is
Yeah.
clear that the critical
Just
factor in
My
this
tidy
no, I
mind-
understand.
My tidy
it
mind.
took me a while
balance
to is
locations
making an
as
Thank you very
assessment
much.
of whether there has been a gross miscarriage of justice. And if so, that's the
how
third
grave
consideration, and then it's
Yeah.
paragraphs 99 and its gravity. I mean, if it's gross, one assumes it is grave, but whether there has been a grave miscarriage of justice, and only then can you properly balance the miscarriage against the foreign policy considerations. In my respectful submission, a provisional view just does not qualify, which weighs in favour of the possibility of
properly,
judicial review. That's at the end of
as a
paragraph
proper
95. So the
exercise
first
of balance
consideration was the
may,
reviewability
as I
of prerogative
accepted
powers.
and asked,
The second
my
consideration was the
be
legitimate
an
expectation
interim,
engendered
a preliminary position that has to be
engendered
taken
by
while
policy
an
statements.
investigation goes on.
And the
But the
third
ordinary
consideration
expectation
was
must be
an
that when the
additional
evidence
legitimate
permits it,
expectation.
A clear
And
view
that's
is
the one
taken.
at 98.
And if a clear
read
view is
together
not
with
taken,
95.
there must
So
be
it's
a
not
real,
rooted
really
in
good
policy statements.
reason
It's in the
for it.
normal.
And
In
in
my
my
respectful
respectful
submission, there isn't a really good reason here. There is no proper expectation that anything is going to change. And you can see, again, the reference to a need for assessment of and the importance of a decision as to whether fundamental rights have been violated at paragraph 104. Because in those paragraphs, 104 and 105, the court suggests some types of cases where judicial review would lie, in other words, where a remedy would be granted. The extreme case where judicial review would lie in relation to diplomatic protection would be if the Foreign and Commonwealth Office were, contrary to its stated practice, to refuse even to consider whether to make diplomatic representations on behalf of a subject whose fundamental rights were being violated. So again, on behalf of a subject whose fundamental rights were being violated. In such unlikely circumstances,
so you can
see there that
it
it
would
would
be
be appropriate for the court to make a mandatory order. There is a balance to the Foreign Secretary to give due consideration to the applicant's case. So a mandatory order might even between the request permitted, but at 105
and
other
the foreign policy
possibilities are also canvassed. And
beyond
beyond
this,
this,
we
we
do
do
not
not expect it's possible to make general propositions. One
In
vital
some cases,
factor,
it might be reasonable to expect the
that
Secretary of
is
State to
one
state
of the
the
vital
result of
factors
considering a
to be
request for
thrown into
assistance.
balance.
In
as
others,
the
it might
policy
not.
recognises.
In some cases, he
is
might
the
be
nature
expected
and
reasons
extent
for
of
his
the
decision.
injustice which
In
he
others,
claims
he
to
might
have
not.
suffered. In some cases,
And then
such
the court
reasons
goes
might
on
be
to say,
able
even
attack,
where there has
and in
been
others,
a
a
gross
gross
miscarriage
miscarriage
of
of
justice.
justice. And then at 106 is the
there
summary
may
perhaps be
of the
overriding reasons of foreign
court's
policy, which
conclusions.
may lead the Secretary of State to decline to intervene. However, unless and until he has formed some judgment as to the gravity of Roman miscarriage, it is impossible for that balance
not
to
an
be
answer
properly
to a claim to
conducted.
say it's the prerogative, it's the
And in
subject
my
matter of
respectful
it's
submission,
determinative. Again, the emphasis that there has to
when
be
you
reason.
look through all of those
three
passages together,
92,
Foreign Office has discretion,
90,
protect British citizens, it's indicated the
8,
ways, in the ways explained,
what
and
British citizens
100. It is clear that
the
expectations are
the
limited and the
critical
discretion is a
factor
wide
in,
one. But there's no reason why its
performing
decision or
that
inaction
balance
should not be reviewed.
is making an
Shown to the
assessment
same
of
way
whether
irrational
there has been a
or contrary
gross
to
miscarriage
legitimate
of justice.
justification. But
if so,
the court
how
cannot
grave
enter forbidden areas,
including
and
decisions
its gravity. I mean, if
foreign
it's gross,
policy,
one assumes it is grave, but
whether
and
there
then
has been
therefore
a
it's highly
grave
miscarriage of any
justice.
decision of the foreign
And only
Commonwealth
then
Office as
can
to
you
whether
properly
to make
balance
representations on a diplomatic
the
level will be intimately
miscarriage
connected
against
to
the foreign
decisions
policy
relating to the
considerations.
country's foreign policy,
In my respectful
but an
submission,
obligation to
provisional
consider the
view
position
does not qualify
of a
as
particular
a,
citizen and consider the
properly,
extent to which some action might be taken on
as a
his
proper
behalf seem
exercise
unlikely
of balance.
itself to impinge on
There
the
may,
area
as I
of
accepted,
and the extent to which it may
my
be
lords,
possible to
be
require more than
a-
Secretary of
an
State
interim
due
preliminary
consideration
position
to
that happens
a request
while
for
an
assistance will
investigation
depend
goes on. But
of
the ordinary
case.
expectation must
So,
be that when the
my
evidence
lords,
permits it,
in my respectful
a
submission,
clear view
this
is
is
taken.
a case
and if a
in
clear
which
view is not taken,
the challenge
there
is
must be
to
a real,
an
really
internal
good
decision
reason for it. And in my
process, respectful submission.
there are no foreign
There isn't
policy
a really good
considerations identified in
There
the
is no
evidence
expectation
as to
that anything
why this
is
court
going to
cannot
change.
review the
And you
internal
can see
decision-making process.
again
the question as to what action to take on the
the need
basis
for assessment
of the concluded view.
and the importance of a
I
decision as to
accept,
whether fundamental rights have been
it
violated.
enters
Paragraph
into
104.
the area
Because
of
in
foreign
those
policy
paragraphs 104 and
considerations.
105
But the
the
question
court,
of whether the appellant has
suggests
the
some
appellant's
types of
brother
cases where
has been the
judicial
victim
review would lie, in other words, where a remedy would be
does
granted.
not, in my respect,
The extreme case where
And,
judicial review would lie in relation to
the-
diplomatic protection would be
the
if
court
the
in
Foreign
Abbasi,
and Commonwealth Office were, contrary to its stated practice, to refuse even to consider whether to make
makes
diplomatic
clear
representations on behalf of
that
the subject whose fundamental
a,
rights were being violated. So
inherently
again,
the
on behalf of
expectation
the
of a
subject
British
whose
citizen
fundamental rights
is
were
a
being
prior
violated.
assessment
In such
when
unlikely
considering
circumstances, we
requests
consider that it would be
for
appropriate
assistance
for
is
the
a
court to make a
prior
mandatory
assessment
order
of whether there's
to
been
the
a
Foreign
miscarriage
Secretary
of
to give
justice
due consideration
its
to the
gravity.
applicant's case. So
we
the mandatory order might
Can
even
we
be
just go back to paragraph
permitted, but
100?
at 105
obviously,
other
one of the most important-
possibilities are
Yes.
also
most important.
canvassed.
in this.
Beyond this, we do
What
not
is
expect it's possible
meant
to make general
by,
propositions. In
uh,
some cases,
until
it might be
unless
reasonable
it's
to
formed
expect the Secretary of State to
some-
state the result of considering a request for
Just
assistance.
some
In others, it might not. In some cases, he might be expected to give reasons for his
My Lord,
decision.
in
others,
my
he
submission,
might
it
not.
means
in some
a
cases,
judgment
such reasons might be
as
able
to the
attack,
gravity of the
and in
miscarriage.
others, they would not.
And then at 106 is the summary of
That
the,
is,
you know, it
court's
has to be a
conclusions.
judgment which is
and one
which is commensurate to the
Roman
question, or which is
Roman
appropriate
one,
to the question that's being
not
asked.
an answer.
And that's
to
why I
a claim to
started
say
off
it's prerogative
by
of the
looking at
subject
the
matter
ways in
is
which
determinative. Again, the
a
emphasis
judgment
that there has
about
to be
whether
a reason
a
at 3
about whether to intervene
foreign
by
officer
requesting release or
protect British citizens,
designating
indicating
individuals
in the ways
for
explained what a
sanctions.
British citizen makes.
Whether a
Respect.
judgment
The
as to whether
expectations are limited and the discretion is a wide
miscarriage of justice
There's
had
no
in
reason
fact
why its
taken
decision or
place,
inaction
the
should not be
rendition had in
reviewable
fact taken
if it
place,
can be
could
shown
make a
that the same
difference.
were irrational
It could make a
or contrary to
difference
legitimate expectation.
for the reasons that I
But
set
the
out.
court cannot enter
And in those
forbidden areas,
circumstances,
including decisions.
it's necessary to make
foreign
a
policy.
judgment about the
And then at 4,
gravity
it's
of the
highly
miscarriage
likely
of justice.
that any decision of
You
the Foreign
say
Commonwealth
some
Office as to whether to make
must mean
representations on a diplomatic level will
final
be intimately
concluded.
connected with decisions relating
Well,
to
in this
foreign
context,
policy,
I say that it
but an
does,
obligation
it
to
does.
consider
I
the position
accept
of a particular
as
citizen
I
and
did
consider
at
the
the start,
extent to which
that
some
first of
action might
all,
be taken on
in
his
the
behalf
early
that seem
stages
unlikely
of a
itself to
detention,
impinge
there is
on
an investigative process
and the
that
extent
has
to
to be
which it
gone
may be
through.
possible to require
And that
more
in
than the
those
Secretary of State give due
early
consideration
stages,
to a
forming
request for assistance will
some
depend
judgment
on the facts
to decide as
case.
whether to
So,
intervene.
My lords,
May,
in my respectful submission, this is
may be satisfied by the
in which
preliminary or the
the
provisional
challenge is
view.
to an internal
but
decision
We are
process.
we are not in the
There
preliminary
are no
stage
foreign
anymore.
policy
We are 2 years on,
and the evidence
has
emerged and is clear.
as
And in
to
my respectful
why
submission,
this court
and it
cannot
may be that this is
review the
this is
internal
purely a point on
decision-making
rationality. The judgment that is
the
made
question
has to be
as to what
a reasonable
action
one to
It
take.
has to be one
on the
that
basis
that
of
is
the
capable
concluded
of
view.
allowing
I
the Secretary of
accept
State
it,
to reach a
it
conclusion on
enters
the question
into,
that he is asking himself. In other
the
words,
area of foreign policy
what is the
considerations.
balance between
But the question
the
of
foreign
whether
policy considerations
appellant has
at play in
appellant's
deciding,
brother
for example,
has been the victim
to
of an extraordinary
announce that a
does
foreign
not,
state has engaged in an extraordinary
And,
rendition. Those are the foreign policy considerations.
court
I balance
in
those against
the miscarriage of justice.
makes
And
clear
if my
that
view is provisional,
inherent
in that
the
balance,
expectation of a British
then
citizen
in my respectful
is a
submission,
prior
it's
assessment
less likely
when considering
that the
requests
balance is going to
for assistance
fall
is a
in
prior
favour
assessment
of making
whether there's been a
a
miscarriage of justice
public statement.
and its gravity.
Because the
Can we,
expectation is that
yes.
the
can we
view
just
may
go back to
change.
Paragraph 100.
this-
Suppose the view is, well, the most important. Court of Appeal
Yes.
judgment looks pretty devastating to us. But meant they did grant stay, and until the matter is on appeal, some to the Supreme Court, and if the Supreme Court were, maybe unexpectedly, but
Well,
yeah,
my lord,
if they were
in my
to
submission, it
reverse
means
the court
a judgment as to
say
the
that
gravity
nothing
of the
wrong with this
miscarriage.
at all,
And
then we,
that is, it has to be a
by
judgment
the
which
Foreign
is
Secretary, would have
commensurate to the question, or
might
which is
have to
appropriate to the
reconsider
question that's being asked.
my
And that's
view.
why I started off
Yes.
by looking at the ways
Well,
in
look,
which
at one
a
point, the
judgment
respondent
about
suggested
whether
that what the
appellant was asking for was a final
about whether to be changed in the
by
by
requesting
judgment.
release or
That is not what
designating
the
individuals
appellant
for
is
sanctions.
asking for.
Whether
I accept
a
that if
judgment as to
some
whether the
entirely unexpected fact came
miscarriage
to
of
light,
justice had in
for
fact
example,
taken place, the extraordinary rendition,
the
had in fact
Nigerian
taken
government
place,
could
suddenly
make a
to
difference.
produce
It could
a
make a difference.
non-forged extradition,
the reasons that I set out,
and in those circumstances,
that had been agreed
it's
with or
necessary to
obtained
make
from the
a
Kenyan
judgment
government.
about
That
the gravity
would be
of
a
the miscarriage
reason
of
for
justice.
reconsidering
you say
a,
some
a,
judgment
a concluded or clear view.
must mean
It's not the appellant's
final
submission
concluded.
that the view is
Well,
fixed.
in this context,
I say that it
forever,
it does. I mean, my
I
appellant's
accept
submission
is that
as I
the
said at
Secretary
the
of State
start,
has got
that
to
first of
conduct
all,
a balancing
in the early
exercise
stages of
between
a
foreign policy
detention,
considerations.
there is an investigative
involved in
process that has to be gone through.
escalating steps,
And that
which
in
is what
those
the appellant is asking
early
for,
stages,
escalated steps and circumstances
forming
where previous steps
some
have worked.
judgment to decide
And in order to
as
conduct that
whether
balancing
to
exercise
intervene,
properly,
she has
may,
got to reach
may be
clear
satisfied
view on the
by
evidence in
preliminary
front of
or
her.
the provisional view.
Unless there is some good
but-
reason not to. We are,
And I've
we are
already
not
showed
in the preliminary
that
stage
there-
anymore.
that the
We are
appeal
2 years on.
It's not a
And the
on
evidence
its face a
is,
good reason not
has
to.
emerged and is clear. And in my
The
respectful
appeal does not
submission,
suggest that
and it
anything
may be
further
that this is purely a point on rationality. The judgment that
In
is
terms of
made
the
has to be
findings of
a
extraordinary
reasonable one.
rendition.
It has to be one
So
that,
in those
that
circumstances, there's
is
no good
capable
reason
of
to
allowing the
and
Secretary of
here I
State
should
to reach a
emphasise that
conclusion
there is
on
of
the
course a
question that he is
distinction
asking
between,
himself.
in other words,
What is
you
the
do
balance
as a result of your
between
and
foreign
the
policy
So
considerations
I accept that one of the
play
factors
in deciding, for
that
example,
the Secretary of State may take
to
into account in
announce
deciding
that a foreign
whether
state
to
is
state
engaged in
an
will be the
extraordinary
possibility
rendition.
of change in the
Those are the foreign
whether
policy
to ask for
considerations.
considerations.
I accept
I
that
balance
at that
those
stage in the analysis,
against the appeal is
the
relevant miscarriage of justice.
Of
And
course, it's not
if
the appellant's case
my
that
view
should
is
change the
provisional,
position, but that's not the argument that
in
I'm
that
making here
balance,
today.
then
The
in my
argument I'm
respectful
making
submission
here
is
today
it's
is that
it's
the
less likely
precursor
that the
for
balance
all
is
of
going
this
to fall in
proper
favour
due
of making
consideration
a public statement,
Bassey says must be
because
carried
the
out,
expectation is that
a
the view may
non-provisional view
change.
in circumstances
This
where
Suppose the view
provisional
is,
view,
well,
I say, is no
Court of
longer
Appeal
appropriate.
judgment looks
Cannot
pretty
be-
devastating
cannot conceivably be
to
said
us,
to be appropriate.
but
No
they
one
did
else
grant
has
a
found it
stay,
necessary to
and
reach a
the
provision
matter is on
through the
appeal
courts,
to the
the
Supreme Court.
United
And if the
Nations.
Supreme Court
And of course,
were,
when a British citizen is
unexpectedly,
subject to an
they
ongoing
were
serious
to
violation of their
reverse the Court
rights,
of Appeal,
which
say that there's nothing wrong with this
puts
matter
them at
at all,
risk in circumstances
Then,
where they're being detained by someone who
we,
has already tried to kill them.
government,
The urgency of reaching a clear view is obvious in my submission.
would have,
So another good reason why a
might
provisional
have to reconsider.
maintained for over 2 years
Yes.
is simply not appropriate. There's
Well,
no
my lord,
evidential basis
at
for
one
it.
point, the
There's no
respondent
rational
suggested
basis
that what
for
the
it.
appellant
it's
was
inappropriate
asking
in
was a
circumstances
final
where
it could not be
a
changed in the form of a
vexed
court
decision
judgment
have to be made about how the
That is not
respondent
what
is going
the
to properly
appellant
deal
is asking.
with an
I
ongoing
accept that if
serious
some
human rights
entirely
violation of one of
unexpected
its
fact
citizens.
came to light. For example,
And in my
the
submission,
Nigerian government
what
was suddenly
Court
to
of Appeal in
produce
Bassi makes
a
clear is
non-forged extradition
an essential
warrant,
first stage,
you know, that
and an
has
essential
been
part
agreed
of the
with or
expectation
obtained from the
is
Kenyan
that
government.
judgment
That
will be reached.
would be a reason for reconsidering
Can I
a
just,
Yes,
that's
a
your first
completely
ground of
clear
appeal,
view.
that the judge
It's not the appellant's
misinterpreted Bassi, or
submission
failed to
that
understand
the
the Bassi,
view is
Yes.
fixed
that when
um,
Bassi talked of
forever.
a
But what
formulated
the
view
appellant's submission
and
is
some
that
judgment,
the Secretary of State
in the
has got
context
to
of
conduct
legitimate
a balancing
expectation,
exercise
it
between
meant
foreign policy
a
considerations
final or firm judgment,
involved in
conclusion, view.
escalating steps, which is what the appellant is asking for.
If the
Escalating
judge
steps
didn't
in
get it wrong, you're
circumstances
still
where
saying,
previous steps
well, on the
were.
facts of this case,
And in order to conduct that balancing
the
exercise
decision was
properly,
irrational.
yes, she has got to. Well,
reach
that's ground two. I mean, I
clear
should
view on
in
the evidence
passing,
in
I
front
should
of
deal with what the judge said,
unless
is
there
that
is
this was
some
a
good
Thames
reason
side
not to.
type,
And I've already
exercise.
showed you,
and that's what
that
Bassi
the-
meant.
that the
is that it was
appeal
simply
is not
on its
an
basis
exercise
of
of
gathering
gathering
information. The
asking
appeal
right
does not
question
suggest
and
that
then
gathering
anything
the
further
right information to allow it to be answered. And in my respectful submission,
in
that is
terms of
obviously
the
wrong.
findings of extraordinary
Conclusions do have to. And
be
so, in those circumstances, there's no good reason to wait
because
and here I should
and those
emphasise
conclusions
that there is,
can
of
be
course, a
challenged, as we
distinction
saw from
between
paragraph 106.3
what you do as a result of
to
your
5 of
and
to
the
6
view.
of the Bassi.
So I
which
accept
is
that one of
because
the
those
factors
conclusions can be
that
challenged
the
as
Secretary of State
irrational.
may take into
So
account in
it's
deciding
not simply an information
whether
gathering
to state the
exercise.
view
That's what the
will
judge.
be the possibility.
That's
of
why the
changing
judge
secret,
rejected the
or
appellant's
whether to ask
argument,
and accept
and
that
it
at
was wrong
that
to do
stage
so.
in the analysis,
There's
simply
the
nothing
appeal is
at all.
relevant to support it, and it conflicts with the language.
Of course,
of
it's
the
not the appellant's case that
Um,
that
so
should change the
speaking for
position, but
myself,
that's not the
I think
argument
it-
that I'm making here today. The argument I'm
Bassi is
making here
the
today
important case.
is that
Although
the
I can't
precursor
remember when I
for all of this
sat on
proper due
under your
consideration
appeal when
that
less
the
than
court in
when
Abbasi
fewer than
says
25
must be carried
authorities were in the
is
bubble, but
reaching
actually
a
this
non-provisional
case,
view in circumstances where
Abbasi,
a
whatever
provisional
it
view, I
decides,
say, is no longer
binding on
appropriate.
us,
Cannot
Mr.
re-
Swift, it's
cannot
binding on
conceivably be
us.
said to be
I
appropriate.
don't think it's suggested.
No one else has found it
it's
necessary
been,
to reach a provisional
altered
view. The
by
courts,
anything subsequent.
the United
So we,
Nations. And of course,
Abbasi was
when
back
a British citizen is
things
subject
like
to an
you
ongoing
may
serious
be right
violation
that
of their
Mr.
rights,
Justice Swift's
which
reference to Tameside is
puts
wide
them
and large.
at
I
risk
still think
in circumstances where they're being detained by someone who
as it
has
seems to
already
me,
tried to kill them.
whether
The
the
urgency
Secretary of
of
State
reaching a
has
clear
failed
view
to comply with
is obvious
you
in my
might call for short the Abbasi
So
obligation.
another
Yes.
good reason why a provisional
My lord, I accept that. I
maintained
agree
for
with
two
it.
over
I mean,
2 years is simply not
some
appropriate. So
additional authorities
evidential
have been
basis
added
for
into
it,
this bundle.
there's no
much
rational
smaller
basis
in
for
the
it. Administrative
and
call
it's
because
inappropriate
precise
to the reason
circumstances
that
where
you've given.
partly to deal with the
Vexed decisions
the
have to be
ground
made
three,
about
how the
which
respondent
suggests
is
that
going
there's
to
no
properly
duty of
deal
fairness in
with an ongoing
these
serious
types of
human rights violation
but,
of one of its citizens. But my lord, yes,
and in my
Abbasi is the key
what
authority.
a Court of Appeal
And
in Abbasi
just
makes
on
clear
on
is
the
that
question of formulated
an essential
final
first
concluded,
stage,
I mean,
final
and
view,
an
I've already
essential
said,
part of the
it's not the
expectation
appellant's case
is that that judgment
will be reached.
it's the appellant's case
Can I-
that the view has to be taken,
That's your first ground of appeal.
which is
that the judge
sufficient to
misinterpreted
allow the
Abbasi
Secretary of
or
State
failed
to
understand
properly
Abbasi.
consider
That
the requests
Abbasi
that are being
talked
made.
of
I mean,
a
that may be
formulated
the
view
better way of
and
formulating it.
some judgment.
And so
in the
that is why I
context of
started
legitimate
off with
expectation,
what difference
it
could it
meant
make?
a
What the
firm
appellant
judgment,
is now asking
conclusion,
for
view.
is an escalated strategy.
But if the
I make
judge
no
didn't
bones
get it
about
wrong, you're
that.
still saying,
It's an
well, on the
escalated
facts of this
strategy
case,
of
the decision was
seeking-
irrational.
yes, publicly. Well, that's
requesting
ground two. I mean, I
Yeah.
should
Publicly,
in passing. I should deal with what the judge
stating
said.
that
Is that this was a
appellant-
Thames
that
side
the appellant's brother, Mr.
type
Kanu,
has been
exercised.
subjected to
and
extraordinary
that that's
rendition,
what Abbasi meant.
imposing
That it was
sanctions.
simply
These
a-
are
a-
escalated
an
steps.
exercise
They
of
go
gathering
beyond simply
information.
raising concerns.
asking the right question and then gathering the right information to allow it
Now,
to be
in
answered.
order
And in my
to
respectful submission, that is
properly consider those escalated conclusions do have to be In my
and,
respectful submission, the respondent has got
because
to address
and those conclusions
whether
can
the
be
conditions
challenged, as we saw from paragraph
for
106,
those
3
escalated requests are
to
met.
5 of to 6 of
And
Abbasi,
in my
which
respectful
is because
submission,
those
that
conclusions can
means
be challenged as irrational.
so he has
it's
to
not
address
simply an
whether there
information
has
gathering
been
exercise.
a breach.
That's what the judge.
of
That's why the
the
judge
appellant's
rejected the appellant's
fundamental rights, not
argument,
provisionally.
and he was wrong to do so.
There's
But
simply
whether it
nothing
has
at all
occurred to support
whether
it,
there
and it
has been
conflicts
an
with the language
extraordinary
rendition, because
so
otherwise
Speaking
he's
for
not
myself,
complying
I think
with the appellant's and Mr.
Abbasi
Kanu's
is the
legitimate
important.
expectation
I can't
that
remember when I
his requests
sat on a
be given due
public
consideration
law appeal when less than
Realistic-
25 authorities
by
were
maintaining a
involved.
provisional
In
stance.
this case,
He
Abbasi,
is stymieing
whatever it
those
decides,
requests
was binding on
before they get out of the starting
binding on
list,
us. I don't think it's suggested
because
it's being
realistically,
altered.
no Secretary of State is going to call
So we
out a
Abbasi,
foreign government for having
prefer back
been
to Tameside.
having,
You may be
been
right.
involved in an
Mr.
extraordinary
Justice Swift's
rendition.
reference to Tameside
where
is wide of the mark, but I
The
still
Secretary of
think
State has only reached a provisional view on that
it seems
question.
to me is whether the Secretary of State has
Or call for
failed
his
to
release.
comply with
Do you accept, as
what
you
you
must,
might call for short the Abbasi obligation.
Abbasi?
Yes.
Well, my Lord, I accept that and I agree with it. I mean,
Says a paragraph
some
in
additional
whether he was to
authorities
make
have been added into this
representations
bundle,
of
which
the
was much smaller in the
entirely for the Secretary of State.
administrative court because
Here,
precisely the reason
There have been
given.
Yes,
plenty of
Partly to deal with the
a fortiori
ground
whether
3,
the
which
Secretary of
suggests
State
that there's no duty of fairness in
the courts cannot
in these
possibly
types
say
of cases.
the Secretary of State must
But my Lord, yes,
go public.
Abbasi is the key
You
authority.
accept that?
And I just,
appreciate that.
on the question of
matter of
formulated,
regret to your
final,
late
concluded, I mean,
is
final
part
view
that
I've already
we are
said,
bound
it's not
by.
the appellant's
See,
case.
Yes.
This is
Abbasi makes that very
fixed.
clear.
It's never been any
It's
part of
really,
the
it's the appellant's case that the
to
view, a view
seek
has to be
to-
taken, which is
obtain
sufficient
any kind of
to
declaration
allow
or
the
order
Secretary
in
of
relation
State
to
to
what steps
properly
should be taken.
consider
This
the requests
about
that are being made,
the decision-making
That may be
process
the
that
better
we
way of,
adopt.
and it really, I mean, it's a pretty simple point,
And so that is why I
Um,
started
is
off
the
with
Secretary of State
what
who is
difference
on
could it make
entitled to continue
what
to
the,
base
what the
a
appellant is
decision
now
as to
asking
what to do,
including on the
is
escalated
an
steps,
escalated
on a provisional
strategy.
view.
in
I
circumstances
make no
where
bones about that.
the evidential picture
Escalated
is
strategy.
about as clear as it can possibly be. Seeking
That's
publicly
that's
requesting
round
release.
one.
It is. Yes.
Publicly
Can I come on
stating
to
that the
ground
that
two?
the appellant's brother, Mr. Kanu, has been subjected to extraordinary rendition, imposing sanctions. These are
That's
escalated
rationality.
steps,
Which
which
is
is beyond
rationality.
simply
I thought you'd
raising
already made
concerns.
solutions on that because
It's certainly going to be short.
alternative,
Now, in order
alternative mirror.
to properly
If
consider
you're right on
those
your first thing,
escalated
you put it either
requests,
on the basis of expectation
in my
or on
respectful
the basis
submission,
of
the
rationality.
respondent has got to address
Well, I do, but I
whether
think
the
the
rationality
conditions
is
or
those
logically
escalated
a
requests
separate
are met.
argument
In the sense that it's even
And
if
in my
he doesn't have a
respectful
legitimate
that
representation that that he has to
concluded
address whether there has
view
been taken. It's
a
irrational
breach
now of
based on the
appellant's
evidence.
fundamental rights, not provisionally,
It's
to-
irrational now for the reasons
but whether it
that
has
That I've already given because
occurred,
the position
whether there has
is,
been an
is so
extraordinary
clear.
rendition.
And
Because
otherwise, in terms of the
he's not
judge's
complying
judgment below,
with the
the
appellant's,
reasoning
Mr.
the judge
Kanu's
gave,
legitimate expectation,
which is at paragraphs
That
31
his
to
requests
32,
be
in
given
Bundle
due
113
consideration.
to 114, he has conflated
Realistically, by
the
maintaining a provision
decision to state
the public,
he is
stymieing
stymieing
those requests and has
Before
said
they get
out of the starting
that it's rational for the Secretary of
because
State to
realistically,
conclude
no
that their view
view
should not be stated.
foreign
the-
government for
the
having
prior
been,
decision
as to what the Secretary of State's
having
view is, been involved in an
That
extraordinary
is something
rendition.
that the
Where
respondent
the
himself
Secretary of State
states
has only reached a provisional view
these
on that
proceedings
in all his
pleadings and
or call for his release.
But do you
Skeleton
accept
arguments,
much
which is to suggest that the rationale for his decision not to
Says a
reach a
paragraph,
concluded
well,
view was
even
that
to make
reaching and stating that view would be
Entirely
contrary to
discretion.
foreign
Yeah.
policy
There
considerations.
have been
But that
plenty of representation.
is
A fortiori,
folding these
whether
two
the
steps together, and you can
Secretary
see
of State,
how the judge does it.
You say you're not
courts cannot
seeking a
possibly
public
say
statement. You can't.
The Secretary of State
You don't.
must.
Well, my lord, I don't want to go as far as say I can't. I'm just in this challenge. This challenge is about.
Yes,
a matter of
that's
regret
good enough
to
for
your
me.
lay clients.
So you're
We
not
are bound
seeking.
by Bassey, and
Yes.
Bassey makes that very clear.
It's never been
public
any part of
statement.
the appellant's case
So therefore,
to seek to
whatever the
obtain any
however
kind
the
of
judge
declaration or order in relation to what steps should be
you
taken.
maintain
This
the
case is
rationality
about
challenge
the
before
decision-making
us,
process that leads.
effectively on the
It
same
really-
basis.
I mean, it's a
that
pretty simple
you've
point
just
in the
outlined.
end. Yes.
So there's
Is
nothing
the
new.
Secretary of State 2 years on entitled? There's to nothing
continue
new
to
except to
base
say that the judge got it
decisions as
wrong
to
when
what
he
to do,
rejected
including
our
the
argument
escalated
on the
steps
basis
on a
that,
provisional view
and you'll
in
see this at paragraph
circumstances
So
where
rather
32.
like my Lord's intervention
The evidential
in relation
picture is
to ground
about
one
as
and
clear as it
Tame
could
side,
possibly
speaking
be.
for myself, I don't think that will
That's
ultimately
that's
matter.
ground one.
What will matter will be ground two and whether or not
Can
you're
I
right
come
about
on
the
to
rationality.
ground
I'm happy
two.
to proceed on the basis that I'm simply advancing the arguments without
You made the
looking.
point that the judge was wrong because he conflated
That's
the two.
rationality.
He conflated it, and as a result, he found that there were foreign policy
Solutions on that,
as to
because
why
it's
the
certainly going to be
alternative,
was maintaining
that's an alternative
his
mirror.
view, was refusing to state
If you're
the
right
view.
on your
And of
first
course,
thing, you put it
my
either
submission,
on the
and
basis
you'll
of
see this in the skeleton
expectation
argument,
or on the
is
basis
that
of
there are no
rationality.
foreign policy reasons. The,
Well,
the Secretary of State
I
hasn't
do, but
identified any rationality foreign is his evidence.
logically
Perhaps
a
gives
separate
none
argument
for
in the sense
maintaining
that
the
it's
provisional
even if
view. He doesn't
internally
have a legitimate
what is identified
that
is
foreign policy reasons for
concluded
not stating the view publicly be taken.
I
It's
absolutely
irrational now, except that foreign policy reasons
Based
have
on
been
the
given for
evidence.
that in the various submissions and so
Yeah.
on.
It's irrational now for
But
the
all
reasons
that has been said
that
about
I've
the
already
internal
because the
view
position
is that the evidence
so
is
clear.
evolving.
Yeah.
And my lord, in
Your
terms
Lordship
of
have
the
my
judge's
submission.
judgment
That's an irrational
alone,
position now.
the reasoning the judge gave, which is at paragraph
so
31
that
to 32,
is round
core bundle
round
round
two.
two. But I should also say before I
has
leave
conflated
that there is a
decision
a
to
judgment
state
in the bundle
the public
in which the court
state
did
the
it
view
publicly and has said that it's
not
rational,
dissimilar,
not exactly
to-
the
for
same,
the
but
Secretary of
similar
State
circumstances,
to
which is the
conclude
Cabot case.
that
17
the view should not be stated.
And in that was the case in
With
which
the prior decision as to what the Secretary of State,
the Secretary of
view
State
is.
was being asked. And that is something that the respondent
to
himself did consistently until
or had to make a decision about whether
in all his
to
sell
sell
arms
pleadings
to
and the coalition and particular
skeleton
Saudi
arguments,
arguments, which is to suggest
you
that
see
the
this is at
rationale
tab
for
17
his
page
decision
535
not to reach a
The
concluded
authorities
view
on
was that reaching and stating that view would be
And one of
contrary
the,
to foreign policy considerations.
criteria
That
one of the criteria
is
the Secretary of State had to
folding
address
these two steps together
was
and
whether
whether
there
there
was
was a risk
how the judge does
that
it.
You
those
say you're
arms
not
might be
seeking a public
used
statement,
in
you can't.
commissions
You
of
don't.
violations
Well, my
of
lord,
international
I don't want to go
humanitarian
as far as say I can't.
I'm just in this challenge.
And what you can see
this
at
challenge is
paragraph-
about
I'm not.
61
That's good enough for me.
to 63.
So you're
Is
not
a very
seeking
similar sort of argument being made by Cat,
public statement.
which is that
So,
the Secretary of State
therefore,
had refused in that case
Whatever
to
however the
reach
judge
any
dealt,
conclusion about whether the
you maintain
coalition
the rationality
of which
challenge
Saudi Arabia
before
was
us,
a part had been
effectively on the
involved
same
in
basis
past
that
violations of international
just outlined.
humanitarian
Yes.
law
So there's nothing new.
when deciding whether there was
There's
a
nothing
risk
new
that
except
it
to
would
say that
commit
the judge got it
future
wrong when he
violations.
rejected
So, yeah.
our argument on the basis that
So you can see the
and you'll see
argument
this at
at
paragraph
So
62.
rather like my
33,
Lord's intervention in relation to
Yes,
and
ground
then
one and
again,
Tameside, speaking for myself,
at
I don't think that will
138
ultimately matter.
to 139.
What will matter will be ground two and whether or not you're right about the rationality.
I'm happy to proceed on the basis that I'm simply advancing the
Before we
arguments
plunge into
without.
this
You
long
made the
debate,
point that the judge was wrong because he conflated the two.
He conflated it, and as a result,
Tell
he
us.
found that there were foreign policy
Why-
reasons as to why the
what
Secretary of
help
State
does it give us
was
other than,
maintaining
um,
his view,
finding the
was
facts?
refusing to
Well,
state the view.
my
And of
lords,
course,
what
my
it-
submission
on this
and
question
you'll
of
see this in the
rationality,
skeleton
it simply
argument,
shows
is
that
that there
the,
are no foreign
the,
policy reasons. The
court
Secretary of
in
State
that
hasn't
case,
identified any foreign policy
and you'll see this
reasons
from
in
paragraphs
his evidence.
138 to 139 and
gives none
139
for maintaining
and
the provisional
145
view internally.
of the
What
judgment.
is identified, of course, is foreign policy
Accepted
reasons for
that
not
given the
stating
wealth
the view
of
publicly.
information and
I
evidence that was
absolutely
available
accept that the,
on
that
whether
foreign
past
policy
violations
reasons have been given for
had
that
been
in the various submissions and so on.
committed, and given the relevance of
But
that,
all that has been said about
to
the
assessing
internal
future
view
risk
is that
the
the evidence
violations would be
involved.
committed in the future.
And
It was
Your Lordship
just
has my
it was
submission
irrational
that is an irrational
not to
position.
now make that assessment. And in particular, the court took
so
into
that,
account
is
that other
round,
important
and authoritative
round
bodies
two. But I should
dealing
also
with
say
rights
before I
and
leave
other
round
such bodies
that
had
there is
reached,
a judgment in
they've
the
been
bundle
able to reach
in
those
which the
conclusions
courts did intervene
themselves.
in
And in my submission, the same
not
sort of
dissimilar,
reasoning
not exactly the
applies
same, but
here.
not dissimilar circumstances.
And I
which is
really
the
rely on it
just to show that
tab
the court
17 of
expressed
the
some
and in that was a
trepidation
case
about
in which reaching a conclusion of irrationality.
the Secretary of State
was being asked in circumstances where the
respondent had said
to
in that case the
international
Trade
or
Secretary
had to make a decision about
had
whether
said that there were extensive
to
foreign
sell
policy
arms to the
considerations
coalition, in
involved in
particular
reaching
Saudi
those
Arabia.
decisions, but it nonetheless found it was
See, this is
irrational
at
to do
tab
so.
17, page
And
535.
it's just an example of the authority where the court
of the court saying you cannot assess
And
this
one of
question
the,
that is before you properly.
without
Criteria,
making
one of the criteria that
kinds
the
of
Secretary of State
judgments
had to address
process
was whether there was a
applies
risk
here.
that those arms might be used.
Can I turn now
in,
to round three?
commissions of
Ben.
violations of international humanitarian law.
This is important.
And
for me
what you
in
can
terms
see
of
at
looking at what the judge
paragraphs
actually said, because the judge
61
concluded that
to
the respondent,
63
when deciding
is a
whether to
very
provide
similar
assistance
sort of argument being made
to
by
Mr.
Kanu.
Kanu, is not which is
exercising
the Secretary of State
had
power
refused in that case
that attracts
to
an obligation reach any conclusion
to act fairly.
about whether the coalition of which Saudi Arabia was a part had been involved in past violations.
That
of
conclusion just
international
simply cannot be sustained
humanitarian
in the
law
light of the GCHQ
when
case,
deciding whether there was a risk,
which
that it
said
was
in
commit
terms
future violations.
that prerogative
So
powers
you can see the
are argument at
reviewable
61 to
on
63.
the basis of
And then
fairness and
again
rationality.
at 138 to 139. My Lord, just it's paragraph 35 of the judgment at 114 where he reaches
Before we plunge
that
into this
conclusion.
long, complicated case in
And
which
because
James
I should give you the
Tell
references
us.
in the GCHQ case that
Why-
the respondent has now
what
accepted
help does it give us
that,
other than
that is right in
what we
his
find in the
skeleton
facts?
argument.
Well,
It's Lord
my Lord,
Diplock,
what
for
on
tab
this
2,
question of rationality, it
410
simply
C to
shows that
411 H,
the
the
court
authorities
in that
bundle at
case,
102 to
and
103.
you'll
See this from paragraphs
Cool, just so I can
138 to
understand.
139 and 13
First ground's
and 145.
legitimate expectation.
Yes,
Second
of the
ground's
judgment.
rationality.
Yes. Accepted that
those will
given
either
the wealth
succeed or
of
fail.
information and evidence that was available
If you succeed
on whether past
on one or other of
violations
those,
had
you don't
been
need this.
committed,
Well,
given
And
the
if
relevance
you
of
fail
that
on 1 and 2,
to
does this
assessing
save you?
future risk, that violations
well,
would be
this
committed in the future.
this is a distinct ground
It
in this
was
sense.
just-
I
it was
appreciate it's a
irrational.
distinct ground
Yes.
of appeal. I'm
Not
just
to
looking at the overall.
that assessment.
How does it
How
fit
does
in?
In
it fit
particular,
in?
the court took into
Even
account
if we
that
were
other
to
important
lose
and
authoritative
on
bodies, including
grounds,
Human Rights Watch and
102,
such bodies,
this ground would
had
still
reached,
have traction.
they've been able to reach
that.
those conclusions themselves. And in my submission, the same sort of
Because
reasoning
it is the
applies
appellant's
here.
case,
And I really
that
rely on
the
it just to show that the court
expressed some
respondent
trepidation about
has an obligation
reaching a
in
conclusion
fairness
of
to either tell
him
what
what
the
the
provisional
provisional
view
where the
is,
respondent had
or
said
at least
that
to
case,
identify the factors
International Trade Secretary had said
which,
that there were extensive foreign
might
policy
cause that view to become
considerations involved in reaching those
a concluded
decisions, but it
cease
nonetheless
being
found
provisional.
it was irrational not to do so. And it's just an
So that
example
the
where
the court saying you cannot
to
assess
shift
this question that is before you
view
from
properly
provisional to
without fear
making
of
these
concluded.
kinds of judgments. And
So
that is the appellant's case.
process.
So it survives.
So it survives because this is premised on the basis
Can I
that
turn now to
provisional
grounds
view is
3?
okay.
Yes.
fairness.
Yes.
I get that.
This
So
is
it's-
important.
I agree, it's not
for me
necessary.
in terms of looking at what the judge actually
if-
said, because the judge concluded
It still
the
might be
respondent
necessary, even if we
when deciding
succeed on
whether to
grounds
provide
1 and 2,
assistance
because there will be a
to,
process that the
Mr.
Secretary of
Kanu
State has to
is
go
not
through
exercising
in order to reach
a power
well, it's
that
ground
attracts
one,
an
not ground
obligation.
two. If I succeed on
act
ground fairly, 2, that it's irrational to maintain a provisional view, that will be the end of it. If
and
I
that
succeed on
conclusion
ground
just
1,
simply
not ground
cannot be sustained,
then
in
there
the
will
light
still
of
be
the
a process that needs to be gone
case,
through by the Secretary of State,
which
to
says
decide
in
whether to
terms
reach a concluded view or not.
that
And if you lose on both,
Prerogative
you say
powers
this is still
are
relevant because it
reviewable.
goes to
Yes,
on the
the
basis of
information, effectively,
fairness
to be
and
provided,
rationality.
you say, in relation to what then would be the still legitimate provisional view.
Yes.
my lord, just it's
Because
paragraph 35
on any
of the
view, a
judgment
provisional
upon
view
1-4, where he reaches
presumably comes
that
with it.
conclusion. The
And
possibility
because
Yeah.
and the question is how.
I should
can
give you the
the,
references in the
appellant,
GCHQ
in
case,
circumstances where the respondent
has
has
repeatedly
repeatedly
said
said he's
that,
not an investigative body,
that is right
assist
in his
the
skeleton argument, assist
him
Lord
in
Diplock
achieving that change.
for tab 2,
You'll forgive the
Or
questions. It's
10C.
just
No, no.
my experience is very
11H.
good to see where these things fit
the
in.
authorities
And
bundle
rather than
102 to
this being a sort
103.
of standalone attack on some part of
Yes.
the
I
judge's
can
reasoning,
understand.
it
Yes.
actually,
The
I fully
first ground's
understand that has a purpose.
legitimate
Yes, well, I'm very
expectation.
grateful.
Yes,
Second
it's
ground's
something that should be
rationality.
identified.
If
So
those will either
my
succeed
lord,
or fail,
the judge
if
was
you
wrong
succeed
because it's
on
inconsistent
one or other
with
of those, you
GCHQ.
don't need, and you were giving us.
I was giving you the paragraph
Well,
numbers
and if
410C
you
to
fail on 1 and
411H.
2, does this save you?
Authorities 102 to 3.
Well, this is
Authority
this
case
is a
102
distinct ground in this sense.
I appreciate it's a distinct ground
Yes.
of appeal. I'm just looking at the overall.
How does it
How does
fit
it
in?
fit in?
So even if we were to lose on grounds 1 and 2, this ground would still have traction. Let me put it like that. Because it is the appellant's case that the
And you can see there
respondent
the reasoning
has an
which is of the
obligation in
majority,
fairness to either tell
the common law
him what the
powers,
provisional
prerogative
view
powers
is,
are amenable. This is at
or
C
at least
onwards
to
of
identify
page
the
10,
factors
to review,
which
subject only
might
to
cause that view to
subject,
become
matters of subject matter.
a concluded view. Cease being
And
provisional.
my lord, without asking you to read it all
So
now,
that the
but those if you
appellant
then
can
your lordship's turned over the
attempt
page, you will
to
see it
shift
411
the view
F
from
to H.
provisional to
As respects procedural
Fear of,
propriety, I see
concluded.
no reason why it should not be
So
a
that
ground
is
for
the
judicial
appellant's
review of a
case.
decision made under the
it
powers of
survives.
So it
as
survives
prerogative.
because this is premised on the basis that
I just
provisional
don't see
view
how
is
this
okay.
applies
Yes.
to the present
I
fact.
get that. I understand.
It is. So it's, I agree, it's not necessary.
Well, my lord, it's simply
if-
that the court
It still
It is-
might
the
be
court has
necessary,
found
even if we succeed
that
on
as a
grounds
matter
1
of
and 2,
principle,
because
there is
there
no
will be a
obligation to
process that the Secretary of State has
because
to go through
of this
in order
type
to
of decision
reach.
that is being taken.
Well, it's ground
Said.
1, really.
And in my
Ground
respect,
2. If I
that is
succeed
wrong.
on ground
All right. Well, if
2,
it's wrong, what's
that it's
right?
irrational to maintain.
Anybody,
that will be the
anybody
end
Yeah.
of it.
in
If I succeed on
life
ground 1,
taking
not
any
ground
decision which
then there will
affects
still be a
anyone
process that needs to be
must
gone through
do
by the
what?
Secretary of State in deciding
Complete
whether to
the
reach
sentence.
Well, my lord, I accept.
And if you lose on
Must
vote,
act
you
fairly
say
is
this
the
is still
answer.
relevant.
That's
as it
complete.
goes
Now,
to
what fairness requires?
the
You're
information
talking about
effectively
procedural fairness.
Yes,
to be
procedural
provided,
fairness.
you
Well, what
say,
did
in relation
procedural,
to
what does
then would be
procedural
the
fairness
still legitimate
require?
provisional view.
Yes,
Sir James,
Yeah,
sir,
because
in his skeleton
on any view, a
paragraph
provisional view
40, he may
presumably
be
comes
right
with
or
it
wrong,
the
that the Secretary of
the
State has
possibility of
regularly
change.
provided
And the
the
question
appellant
is how
with
can
updates
the
and steps
appellant,
taken,
in circumstances
as
where
well
the
as
respondent
why
has
the Secretary
repeatedly
of
said
State has
he's
chosen
not
not
an
to
investigative
pursue
body,
a certain
assist
course in
yes,
Mr. Kanu's case.
assist him in
And
achieving
what
that.
more did
You will forgive the questions.
the
It's just
obligation
my
of
experience is very
procedural
good to see
fairness
where these things fit in, and rather than
This
being
again
a sort
relate
of
all of
standalone
these
attack
grounds
on
of
some
challenge
part of
relate
the judge's
to the
reasoning, it actually,
provisional view.
I fully
So
understand
they-
that has a
it's-
purpose.
Yes, the
Well, I'm
issue
very
is
grateful. It's something I should have
the
identified.
Secretary of State has reached a provisional view. We
so,
don't know what it is.
My lord,
And so
the
it's
judge was
therefore
wrong
not possible
because it's
to
inconsistent
challenge
with
the view if it
GCHQ.
were
And you were giving us
rational. I was giving you the paragraph numbers 410C
or
to
otherwise
411H.
mistaken.
Authority is
And
102.
we also don't know why
Authority page 10.
the view has remained
This is tab
provisional.
2 of the bundle. Why is the view provisional in the face of all of these developments? The only explanation that has been given is involving evidence, but as I've already explained, that does not stack up. We don't know, for example, whether the Secretary of State has sources that have told him that something is going to happen in these proceedings that will affect the evidence.
And you can
We don't
see
know
there the
Think
reasoning,
because
which is of the
so
majority,
and that's my submission. But
the common
if
law
there-
powers,
if
prerogative
the Secretary of
powers
State is
are amenable, this is
misled,
at
for
C,
example, or is
onwards of
misunderstood,
page 410,
is mistaken
to review,
on the position in circumstances
Subject
where, as
only
I've said,
to
she has said she's
the subject
she doesn't
matters of
have an
subject matter.
investigative role, then the
And,
appellant could correct those mistakes.
My lord, without
But
asking you to
we
read it
don't
all
know.
now,
We don't have
those-
any of this
if you
information.
then,
Now, on
your lordship's
ordinary
turned
principles
over
of
the page,
procedural
you'll see
fairness,
for
a decision of this
11F
kind,
to
which, as
H,
I've said,
as respects procedural
has
propriety,
the
I
capacity
see
to
no
influence
reason why it should not be a
what
ground
steps
for
are
judicial
taken
review
on
of a decision
sanctions,
made
on
the powers
public
which
statements, on
exercise the
private
prerogative.
representations to the Nigerian government, on
I
those
just don't see
escalated
how this
steps. In ordinary, any
powers
ordinary
doesn't
situation, we would be entitled to know
don't.
what the reasons were for the provisional.
I-
Well, my lord, it's
Very
simply
bad.
that the court
That's a very broad
The court
brush,
has found
brush assertion.
that, as a matter of principle,
me
there is no obligation to act fairly
Right for the case.
because of this
Well, my
type
lord,
of decision that is being taken. That's what
it may be
said.
said,
And
and my
it's
duty
your
then very
submission.
quickly to
That's
say
it's
it's
wrong.
All right. Well, if it's wrong,
So it's
it's
tab
wrong.
4.
Anybody in public life,
It's page
taking
560.
any decision which affects anybody must do what? Complete the sentence.
Well, my lord, I accept must act fairly is the answer. That's completely set. Now, what fairness requires?
You're
of
talking
course-
about procedural fairness.
Yes, procedural fairness.
Well, what does procedural fairness?
So page 156 in the bundle.
Sir James,
And it's
sir,
paragraph,
skeleton paragraph.
D
D to
onwards.
G, it's a
D
very
to G.
famous passage.
It's very famous, and really,
Secretary of State has regularly provided the
this
appellant
relates to an act
with
of Parliament,
updates
but in
and
my
steps
submission,
taken,
as
as well as
I've said,
why
it
the
applies
Secretary of
equally,
State has
and that
chosen not to
GCHQ makes
pursue
clear
a certain
to
course in
prerogative powers.
Mr. Kanu's case. And what more did
There's
the
no reason why
obligation
the
of
same.
procedural
I mean,
fairness?
it's a common law.
Right. This
Or
would
duty
again
to act
relate.
fairly.
All of these
Yes.
grounds of challenge
So
relate
the standards
to
of
the
fairness. So I'm going
provisional
to
view.
skip over one
So
on the basis that it's
the-
clear that it
the
applies
issue is
in every.
the Secretary of
in
State
relation to
has reached a
prerogative
provisional
powers in
view. We
exactly
don't know
the
what
same
it
way
is.
as it does.
And so
in
it's
statute,
therefore not possible to
The standards
challenge
of fairness are
the
not
view.
immutable. They may change with the passage of
irrational,
time, both in the general and in their application to
or
decisions
otherwise
of I
mistaken.
accept that. The principles
and
of fairness
it-
not to
we
be
also don't know
by
why
rote identically.
The view has
What
remained
fairness
provisional.
demands is dependent on the context of the decision,
Why
and this is to be
is the
taken
view
into account in
provisional?
all its aspects.
face of all of these
4, an
developments.
essential feature of the context
The
of the
only
statute,
explanation
that
that
doesn't
being
apply
given
here.
is evolving
5,
evidence.
fairness
As I've
will
already
very
explained,
often require
that does not
that a
stack
person who
up.
may be adversely affected by the decision.
We don't
in
know,
this
for
case,
example, whether
to maintain a provisional
the
view,
Secretary of State
will have an
has
opportunity
sources
to make
that have
representations on his own behalf
told
either before the
him
decision is taken
that something
or
is going
with
to
a view to
happen
producing
in
a
these
favourable
proceedings
result, a concluded view,
that will affect
or
the
after
evidence.
it's taken
So
with
we
a view
don't
to
know that.
procuring its modification,
We
or both.
think
And the
not,
after it's taken
because
usually leads to
so
reasons
clear.
being given.
And that's
At
my
6,
submission.
since the person affected
Thus,
usually cannot make
if
worthwhile
there-
representations
if the
without
Secretary
knowing
of
what
State
factors
is
may
being
weigh against his
misled,
interests,
for example,
why
or
the, in other words,
misunderstood,
here we say
is
why the
mistaken
provisional view is being maintained,
on the position,
fairness will very
in
often
certain
require that
instances
he's
where, as
informed
I've
of the
said,
gist of
she
the
has
case,
said
which
she
he has to answer.
she doesn't have an
And
investigative
then the
role,
explanation
then
as to why
the
that is so
appellant
is
could
given
correct
at
those mistakes.
563,
But we don't
And
know,
this is in
we don't have
relation
any of this
to
information.
a
Now, on ordinary
someone who
principles of procedural
is
fairness,
facing
a decision of this kind, which, as
longer
I've
prison
said,
sentence.
has the capacity to
And I
influence
say obviously in
what
this
steps
context,
are taken
the
on
gravity
sanctions,
of
on
the situation
public statements, on
is at
private
least as
representations to the Nigerian government, on
as
those
serious.
escalated
It's
steps.
at least as great.
In any ordinary
you see at
situation,
563G,
we would be entitled to know what the reasons were for the
now
provision.
the court addresses whether an
that's
explicit
a very
disclosure
broad
of the
brush
substance of the
search.
matters on which the decision maker intends to
seems to me
proceed
to,
must be disclosed.
Derive the case.
Whether such a duty exists, how far it
Well,
goes,
my
and how
lords,
it should be performed depends so entirely on the
maybe,
circumstances of the
we
individual
should
case
look at
that I
duty
prefer not
then
to
very
raise
quickly
many
to
general
see what it
discussions on
says.
the subject. Rather, I would simply ask that the
tab
life
4.
of his future depends vitally on the decision of the Home Secretary as to the penal element.
Page
Here
560.
for the reasons I've explained as to whether a view is taken on his extraordinary rendition, and who has a right to make representations upon it, and no one has suggested that the appellant is not able to make representations on what should happen, should know what factors the Home Secretary will take into account. In my view, he does possess this right. Without it, there is a page 156 in the bundle, and it's some opinion which he could challenge, some policy
D
change
to
onwards.
G, it's a very famous passage.
It's very famous, and really.
So in my respectful submission here,
This relates to
all
an act
the
of
appellant
Parliament,
is
but in
asking
my
us to
submission,
know,
as
what
I've
the
said, it
provisional
applies
view is,
equally.
that
And
if there are,
GCHQ
and there
makes
haven't
clear
yet been,
to
identified reasons why he cannot be told, for example, on the grounds that he might
there's no
not
reason why the
keep it
same.
secret.
I mean,
that he might
it's a common law
to the
right
attention
or
of the
duty
Nigerian
to act
government,
fairly.
and
Yeah.
therefore engage
So
on the foreign policy.
standards of fairness.
considerations
So
of the
I'm
public
going to
statement.
skip over one on the
If,
basis that it's clear
that position were
that it
taken, and there's
applies
no evidence
in
to
every
that effect. But if
in
it
relation
were,
to
at the
prerogative
very least,
powers
you
in
ought to
exactly
be
the same
told
way as
what
it does
factors
in
have
statute.
caused
The standards of fairness are not
to
immediate.
make a provision.
They may change with the passage of
So
time, both
that
in the general
he
and in
can,
the
2 years after
decisions
his
of
first
so I accept that.
persuade
The principles of
Secretary
fairness not to
State
be
reach a
applied by
conclusion.
rote identically. What
That's
fairness demands
what
is
he's
dependent
asking.
on the context of the decision,
Because
and
the
this is to be
basis
taken
on which
into
the
account in
provisional
all
view
its
is
aspects.
taken,
4, an
may be
essential
erroneous.
feature of the context is the statute. That doesn't apply here.
And my lord, I was
5,
going to
fairness will very often
I'm
require
conscious of the time.
that a person who may
Just
be
give you
adversely
some
affected by
passages,
the
just in
decision,
terms of
in this case,
one of the
to
points that's made
maintain
by
a
the Secretary
provisional
of
view,
State
will have an
is skeleton
opportunity to make
argument is,
representations on his own behalf
yes,
before the decision is taken.
the
or
right
with
of
a view to
fairness does
producing a
arise in
favourable
prerogative
result,
case, but there still needs to be
included
some
here,
reason
or after it's
why
taken with a
there
view
is
to
a duty
procuring
of
its
fairness
modification.
in an
Or
individual
both, and the
situation.
after
So
it's
that doesn't
taken
go
usually
to
leads to
the
reasons being
context
given.
of what fairness
At 6,
requires, but whether
since the
fairness
person
arises
affected
at
usually
all.
cannot
It's still
make
the
worthwhile
Secretary of State's
representations
position
without knowing what
that the
factors
duty
may
to
weigh
act
against his
fairly,
interests,
whatever that
why
may
the, in
require,
other words,
doesn't
here
arise
we
at
say
all.
why the provisional
There is no
view
duty
is
to
being
act fairly,
maintained.
says the Secretary of
Fairness
State.
will very often require that
And
he's
in my
informed of
submission,
the
the
gist
Secretary
of
of
the case
State's
which he has to
submitted
answer.
position on this, like the judge,
And
is
then the
wrong.
explanation as to why
there
that
doesn't
is
need
so
to be-
You may be right.
is given
you
at
may be right
5,
about that.
6.3,
One talks about the duty of the procedure.
and this is in relation
rather
to
than the
someone who
substance of the
is
result.
facing
Then,
a longer prison sentence.
You say that there,
And I say, obviously, in
been
this context, the gravity of
at
the
every
situation
stage,
is at
duty
least as
Secretary of
as
State
serious.
to
It's at least as grave.
why
You see at 563G,
is taking
the
or
court
is not
addresses whether
particular.
an explicit
Yes.
disclosure of the
So far as
substance of the
possible.
matters
Now,
on
I
which the decision maker
accept,
intends to
that
proceed
there
must
may,
be
in
disclosed.
some circumstances,
Whether such a
be
duty
foreign
exists, how
policy
far it goes, and how it
considerations
should be performed
that
depends
may
so
come
entirely
into
on the
play, but
circumstances of the
what
individual case that I
the
prefer not to reason from any
court
general
has made
proposition on the
clear,
subject.
in
Rather, I would simply ask that the
GCHQ,
reliance
is that
future depends
you
vitally
can't just
on
assert
the decision of the Home
foreign
Secretary
policy
as to the penal
considerations.
element.
You have to provide
And
evidence
here we
as
say,
to
for
why
reasons I've
those
explained, as to
considerations
whether
preclude
a
you
view is taken
from
on
doing
his
what would
particular
otherwise be
rendition,
required as
and
a
who has
matter
a
of
right to make
fairness.
representations
That's
on
what
it,
the court found
and no one
in
has suggested
GCHQ.
that.
And there's been
uh,
no such evidence here.
the appellant is
There's
not
been
able
no
to make
explanation
representations on what
as to
should happen,
why,
should know what
the-
factors the Home Secretary
no
would take
evidence as
into
to why
account.
the
In my
appellant
view, he
cannot
does
be
possess this right, for without it,
or
there is a risk that
have,
some
despite
supposed
all
facts
these
which he could
developments,
controvert, some opinion which he could challenge, some policy which he could
persuaded
argue
the
against,
Secretary
might
of State
right,
to
wrongly
go unanswered what it is that she
And so
thinks
in my
he
respectful
thinks is
submission
going to
here,
happen.
what all the appellant is asking is to know,
And my lord, first of all,
what the
there are a
provision
couple of
is
authorities
in-
that I just want
if
to
there
give
are,
you
and there haven't
references
yet been,
in which I
and
might
identify
identify
reasons why
Yes,
he
sir.
cannot be
So,
told, for example,
Yusuf,
um,
in the Court of Appeal,
on the
tab
grounds that
12,
he might not
authorities
secret,
388,
come to
page 388,
attention of
at
the
page
Nigerian
402,
government, and therefore engage all the foreign
Law
policy
Justice laws
considerations
at
of
paragraph
statement
23 to 24.
if that position were taken, and
A
there's no
judicial
evidence,
review of
to that
prerogative
effect,
power
if it
must
were,
found
at the
entirely
very
on
least, he
standards
ought to
which
be
are the
told
product of the
what
common law.
factors
Of these reason
and
and have
fairness are the cornerstones.
caused the
So
respondent
it's really just to
maintain a
emphasise that
provisional
the
view.
duty of
So
fairness
that
comes from
he
the
can,
common
2
law.
years
This is a
after
common law
his
first
power.
detention. You don't need to
Persuade
anything else
Secretary of
to
State
impose a
to
duty
reach a
of
concluded
fairness.
view. It's the Secretary of State
That's
what he's
that
asking
has
to show
because
why
the basis on which
the duty of fairness does not
taken
apply in this context. It's
may
not
be
the
erroneous.
court who has to prove or
And my lord, I
find
was going
some
to,
basis
I'm conscious of the
for,
time.
a duty of
Just
fairness
give you
to
some
arise.
passages just in terms of
indeed as
one of the points that's
and
made by the
this
Secretary
is
of
not
State
in the authorities
is
is
skeletal
so well known.
argument.
It
It's
is
not necessary
Yes,
for it to be in my
the right of
in my
fairness
submission,
does
which is
arise in
in Board of
prerogative cases,
Education
but there
and
still
Rights.
needs to be
This is
some
the point
reason
that I
why
made. There is a
Lord
duty of
Lawburn
fairness in
famously said,
situation
listen,
fairly to
that doesn't go
exercised
to
as a duty
the context of
lying
what
upon
fairness
anyone
requires, but
who
whether
decides
fairness
anything.
arises at all. It's still the Secretary of State's position that the duty to act fairly, whatever that may require, doesn't arise
to
at
decisions
all.
with grave
There is
consequences.
no duty to act fairly,
And
says
there
the
is a
Secretary
case
of
in the
State.
bundle
And
about
in my
the
submission,
prerogative
the
of
Secretary of
mercy.
State, again, this
The
is all
submission
to
position
do
on
with
this, whose
like the
lives,
judges, is
um,
wrong.
and
There doesn't
liberties
need to
are
be
You may
being
be right. You may
State.
be right about
This
that.
is Lewis
But one
and
talks
Attorney
about the
General
duty of procedural
Privy Council
fairness,
case
rather
2001 2 AC 50. It's tab 7,
Substance of
authorities
the
2
result.
to 11.
Then
And the relevant passages are 76B
there
to F and
been
78E to F,
every
just
state
emphasising that the duty
duty
to act
on
fairly is even
Secretary
more
of State
acute
to
in
explain
cases where
why
people's fundamental
he,
rights and right to life are
is taking or
engaged,
is not
as in my submission they are
State.
here. Yes, so far as possible. Now, I
So,
accept
for
that
all
there
those
may,
reasons,
in
my
some
lord,
circumstances, be foreign policy
it's my
considerations
submission
that
Judge got
that may come into play.
the
But they,
Secretary of State
what
got it wrong.
the
Neither court has
considered
considered the
clear,
question my lord
in
asked me,
GCHQ,
which is what does fairness
is
require
that
in this
you
case?
can't just assert
They didn't
foreign
because they
policy
assumed that they didn't
considerations.
need.
You have to
The
provide
Secretary of State
evidence
did not need to act
as to why those considerations
for that reason alone,
preclude you
the appeal should
from
be
doing what would otherwise
allowed.
be required as a matter
The
of
Secretary of
fairness.
State must now ask
That's
us
what the court
what is
found
required
in
as a matter of
GCHQ.
fairness.
And there's
And
been
why
no such evidence. There's been
appellant
no
cannot,
explanation as
to
to
be
why
told,
no evidence as to
given
why
the
the
information
appellant
that he
cannot be
seeks.
told what factors have, despite all these developments, persuaded the Secretary of State to maintain a provisional view.
Thank you very much,
What it is
Mr. Roy.
that she
You've been most
thinks
helpful.
he thinks is going to happen.
2:05, Sir James.
And my lord, there are a couple of authorities that I just wanted to give you references in. I might as well do if you
Yes,
are
sir.
willing to sit.
Yes.
Yusuf in the Court of Appeal, tab 12, authorities 388, page 388 at page 402. Law Justice laws at paragraphs 23 to 24.
Yes.
A judicial review of prerogative power must found entirely on standards which are the product of the common law, Of these, reason and fairness are the cornerstones. So it's really just to emphasise that the duty of fairness comes from the common law, and this is a common law power. You don't need anything else to impose a duty of fairness. It's the Secretary of State that has to show why the duty of fairness does not apply in this context. It's not the appellant who has to prove or find some basis for a duty of fairness to arise. And indeed, as this is not in the authorities bundle, but it's so well known, it's not necessary for it to be in my submission, which is in Board of Education and Rice, and this is the point I think my Lord made. Lord Lawburn famously said, listening fairly to both sides is a duty lying upon anyone who decides anything.
Well, yes.
But of course, it applies with special rigour, that duty, to decisions with grave consequences. And there is a case in the bundle about the prerogative of mercy. Again, this is all to do with people whose lives and liberties are at stake. This is Lewis and Attorney General, Privy Council case, 2001 2AC 50. It's tab 7, authorities 211. And the relevant passages are 76B to F and 78E to F, just emphasising that the duty to act fairly is even more acute in cases where people's fundamental rights and right to life are engaged, as in my submission they are here. So for all those reasons, my Lord, it's my submission the judge got it wrong. The Secretary of State got it wrong. Neither of them considered the question my Lord asked me, which is, what does fairness require in this case? They didn't, because they assumed that they didn't need, that the Secretary of State did not need to act fairly. And so for that reason alone, the appeal should be allowed. The Secretary of State must now ask herself what is required as a matter of fairness and why the appellant cannot be told, be given the information that he seeks.
Thank you very much, Ms. Kilroy. You've been most helpful. 2:05, Sir James.